supplementary list, page 1, 1 to 5.
मतलब item number 3 है prefer 2 weeks time.
पोस्टिंग कर देवे, डेट कर देवे, डेट नहीं
Council 4.
कर दे.
Page 2, page 2, 17.
Item number.
No.
Item number now. After launch, Mr. On paper, Mr. Pujari.
We commencing 4th.
से पासवर्ड चाहते सेटा पासवर्ड आम पढ़ला बेले कही था एबे कहले पासवर्ड कोन एबे होची कि एबे अर्जनमेंट लिखा हो नॉट अर्जन करंतुनी हला.
Page 3, 18 to 27.
Your Lordship's item 20, there is
Yes.
a defect pointed out by the SR that has not
It has to be, if it is defective, it has to be pointed out.
Yes, Your Lordship, I'll just.
But no, I have to pass an order. By mentioning, I am not giving any preference. If you are not there, then request any of your friend. Yes. How much time you are requiring? To remove 1 week. Your name, madam?
Show me das.
You are writing DAS. Okay. That order will be passed. Yes.
Page 4, 28 to 34.
Pardon, mention my lord, 30, item number 32. Kindly adjourn this matter 2 weeks.
Date कर दो.
We commencing page 3.
Other side inform करछन्नी
କରିଦେବି
କରି ଦେବେନି नो ଏବେ କରନ୍ତୁନି କଲା ପରେ କହିବେ ହେଲା.
ଆଜ୍ଞା.
The problem is they are coming in the afternoon and saying that we are not informed.
Okay, my lord.
अपन जानते हैं other side की appear करछन्नी. Do you know the council also?
No, my lord. This
That's the problem.
this
We can't do that unilateral. Next. Please rotate, but let us see. କେବେ ଆପଣ କହୁଛନ୍ତି କେବେ କହିଲେ?
We commencing page.
Please have the courtesy of informing the other side. In after notice matter, when you are not adjourning, the other side should know.
Actually, my lord, the 23rd ମୁଁ appeal କରିଥିଲି first time.
ମୁଁ
I
କଣ
need-
କହୁଛି ଆପଣ କଣ କହୁଛନ୍ତି? ମୁଁ other side ରେ appeal କରୁନାହିଁ. Are you sure? ମତେ କାହିଁ କହୁଛନ୍ତି? ଆପଣ other side କୁ ଜଣେଇବେ ଯେ ଆପଣ adjourn କରୁଛନ୍ତି because it is after notice matter. They are waiting for hearing.
Okay.
So that I am saying. And when I ask you that who is the other side counsel, you even do not know. You are something else. Then you are saying ମୁଁ ପ୍ରତ୍ୟେକ ଠାରୁ appeal କରିଥିଲି. So where we are heading, our conversation is not to the point, madam. Yes.
Page 5, 35 to 38.
Item 37, Your Lordship. I
Yes.
pray for a short adjournment in the first item. I have already intimated my friend is
Mr.
there.
Ansari,
Yes, Your Lordship.
agree for a date?
Yes, Your Lordship. Yes, Your Lordship. Yes.
I have already intimated him in the morning.
Date upon which-
Any short date, as per Your Lordship convenience, Your Lordship.
Today is not convenient. I am not seeking convenience from you.
No. For adjournment date,
So I was saying as per Lordship's convenience, as if I am seeking convenience for adjourning
I'm
matters.
sorry for that, Your Lordship.
I am extremely sorry that you are pretending as if I am seeking convenience from you. I am also equally sorry. Yes. अरे कहबे ना नहीं बेटा ଆମେ ରହିବା म्यूट ହେଇକି ରହିବା.
Any day.
ଆରମ୍ଭ ଟିକେ ସରୁଛି
16th or 23rd, any week commencing 16th or 23rd.
କେବେ ଆପଣ କହିପାରିବ 16 23 କହୁଛନ୍ତି?
We commencing 23.
In that
We commencing 23rd.
item 37, that sub item, both are connected. I'm
Right.
typing for the petitioner.
সেটা
Right. As well.
we commencing 23rd.
23rd of March, Your Lordship. 23rd of March.
Yes, we commencing 23rd.
Grateful, Your Lordship. Grateful.
Both these matters.
Well, it's
Page 6, 39 to 43.
item 36.
Huh. Yes.
Well, it's item 36. I pray for any other day.
Kindly inform the other side.
My lord, I am for the other side. Here, my lord, what has happened? They are seeking transfer of 2 cases. One case has already been culminated in a decree of divorce, which is under challenge in matter. So one TRPC has become infructuous.
ସେଟା କୋଉଟା?
TRPC does.
ସେଟା କୋଉଟା? TRPC 147. କେବେ ଡିକ୍ରି ହେଲା?
Judgment ହେଇଛି final. let him also take instruction because they have filed a matter. My lord, one TRPC that 147, it has culminated in a decree of
The relationship between husband and wife ended up in a divorce.
divorce.
So same with the lawyer and the client. For every case, different counsel. So he doesn't know, most likely.
Both of us are same counsels.
So, I mean, the other side. So, other side ki nahanti.
Other side, he
Sita jannahanti je mata bisare.
same file person.
ଜାଣିଛନ୍ତି ମାଟା?
No, it's-
ଆପଣ ଯୋଉ ଦେଖୁନାହାନ୍ତି ଯୋଉ
I will take instruction on that.
Nodding, at times nodding head like this is also yes. He doesn't know. କେବେ judgment କେବେ ହେଲା CP ରେ?
Sir, judgment ହେଇଛି. So, judgment has been passed, that I know, but as my client instructed me.
MATA number? ଆପଣଙ୍କ ନାଁଟା sir?
Alice Gaurav Das on behalf of Mr. Enlek.
ଗୌରବ ଆପଣ ପାୱାର ନାହିଁ ଆଚ୍ଛା ଜି ଦାସ ତ ଅଛି
My lords.
yes
But it has ended in a matter. It is my instruction.
So what I pray, my lords, let it reach my lords, my senior will appraise. If there has been any matter has been.
ଆରେ ଆପଣ ବି ଏଇଥିରେ ଗଣତରେ why you are so jittery
Also, I
do
have.
you understand what he is saying
My lords.
so then what is the senior how the senior will do I mean improve the
Yes, I will take
so
instruction.
no instructions are how from the judge or from the Mata bench division bench
No, also I will.
what you are saying जो सुभाषिष कुमार बेहरा एटा किए माटा फाइल करछंदी सुभाषिष कुमार बेहरा
Yes.
तो नारे सुभाषिष कुमार बेहरा माटा देखिले आपण काम मत करे आइटम 36
Right.
तो देखि त हाई कोर्ट डाटाबेस केबे चाहू जदी आपण
Any day, my lords, next week or.
इनी तो नाही आई बीन सर्चिंग सकाळ एनी डे कहले कन्वीनिएंट माइलर पेजेस इट वाला
My
नाही
lords, March second week.
टुडे इज द मोस्ट कन्वीनिएंट डेट फॉर मी मार्च
March second week, my lords, any day.
Mr. Bose second week 9th or 16th केबे
Ninth.
9th comment but I'll pass that order when it reaches I'll find out
Yes,
if
ma'am.
matter is there then there's no point in keeping matters pending
Instruction that judgment.
no what is happening in many matters where there is the main case is not pending then still the TRPC and other matters are kept pending here so what you are saying perhaps he might not have been instructed also
He might not have been.
केबे कहले 16 we commencing 16
Again.
yes next
41 minor. That TRPC.
yes
The husband has filed TRPC from transferring the case from Sundargarh Family Court to Sonpur.
yes
My lord, your lordship may allow their application. I also agree to that.
I am for the petitioner.
so sound
Yes, my lord.
allowed just file a memo
My lord.
but don't concede. I mean, the petition is, I mean, the language, whatever you want, let it be used.
My lord, my client has authorized me to.
Okay, then file a memo. कागज तो दियो sir.
My lord, wife also residing at Sonpur. There
अरे
is-
फिर पता ना फिर बॉम्बे ट्रांसफर करिए कौन अच्छी कटक ट्रांसफर करिए. It will go on. The saga continues.
Family Court Sonpur, my lord. We both.
Yes. I'll pass that order. I'll pass. Right now, I'm noting it.
My lord, I am also signing.
Bargarh Sonpur.
Na, Sundargarh Sonpur.
Sundargarh Sonpur.
Civil judge, senior division, Sundargarh to.
They had filed a civil before civil judge Sundargarh divorce.
The petition would be there. No? Petition है लिखा है क्यों? So I'll pass that.
But they have prayed Hon'Ble or Sonpur. My lord, we have agreed for Sonpur.
Sonpur. Okay.
Sonpur Family Court Sonpur.
It is. बस इसको ये कर देबे 25 26
No. My lord, we are filing a memo that both party agreed for Judge
correct,
Family
correct.
Court Sonpur.
yes next
Item 1,
One thing I will just say, my lord. I am aware that my lord is not fixing a timeline, Your Lordship may only say
They will cooperate.
decided expeditiously without granting frivolous adjournments.
Those things I will not do. Because the earlier cases, frivolous adjournments are being granted. You must understand that whether the glass is half empty or half full.
It is for my Lord to say in what way your Lordship will deal. Just it's a prayer from my side
Absolutely.
that it may be decided expeditiously.
Correct, so the parties have
Parties will
to
cooperate. That will also do, man.
Yes, yes.
My lord, joint affidavit is in flag F, my lord. The matter has been compromised between.
Yes.
The last occasion you were not there, so that is how so he mentioned that since you were not there, so we thought that we should be. And affidavit is on record. Ms. Aditi Hota for the petitioner, Mr. Rakesh Kumar Malik for the opposite party. You just both of you take your seat. I'll dictate the order.
Yes,
So take some time. The petitioner husband in the marriage is before this court, seeking revision of the judgment dated 16/4/2016, passed by the Learned Judge, Family Court, Bhubaneswar, in criminal proceeding number 131 of 2015. By the said judgment, the petition filed by the wife in the marriage and two minor children born from the wedlock. This petition filed लिख लेंगे. Petition filed by so and so under section 125 of CRPC into brackets since repealed and substituted by perimeter provisions contained in LNSS 2023 bracket closed. Seeking monthly maintenance at rupees 20,000 for the mother and two children. Mara. The petition was favored by the Learned Judge, Family Court, however, directing monthly maintenance of rupees 6,000 for the mother and 3,000 to the petition number 3 child. And 3,000 for one of the child. One of the child. Stop. A joint affidavit, stuff. A joint affidavit has been filed on 12th March 2020. Joint affidavit 18 ମସିହାର
ଆଜ୍ଞା
ଓ ସେବେଠୁ ପେଣ୍ଡିଂ ରଖିଛନ୍ତି
ଆଜ୍ଞା
ଏଇଟା ବି ଆପଣ ମାନେ ଏମିତି କଣ କରୁଛନ୍ତି
ମେମୋ ଦେଲେ ଫାଇଲ ଉଠୁ
ଆଉ ଖାଲି ଆପଣ ସମସ୍ତଙ୍କୁ କୁହାଯାଉଛି ଯେ କେସ୍ ପେଣ୍ଡିଂ ରହୁଛି ମୁଁ ଭାବିଲି ବୋଧେ ଆପଣ ଗୋଟେ ବଡ ଯୁଗାନ୍ତକାରୀ ପଦକ୍ଷେପ ନେଲେ ଯାହା ସରିଗଲା 26 ମସିହାରେ affidavit 18 ମସିହାର
ହଁ ଫାଇଲ
so my entire perception goes completely turns upside down.
ମେମୋ ଫାଇଲ ଉଠୁ
All clear? So it actually dekha jane date center. So that is how I found it filed on 12th March 2018. Seeking to withdraw the present, seeking to close the present proceeding. Para. The affidavit contains signature of both the parties, also the learned counsel for the appearing parties. Stop. Accordingly, the petition stands disposed of. Copy of this order shall be forwarded to the learned judge, Family Court. So and so to be kept in the records of so and so. Yes. Yes, next please.
Item 2,
So Mahanti.
Within 1 week, I will file requisite, newly added party member. Opposite party 4 men.
Not your lordships of assignment. Court number 21.
Subject matter ta sir?
Yeah, agriculture marketing, production market.
Oh, procurement. Procurement it nahi, it is distribution.
Aye.
But jaha chawla phalo nebe, tole PDS control. The matter has been pending since the matter has been is pending since the last 36 वर्ष हो गला, last 27 years. So it is brought to this court's notice that the subject matter, that is procurement of paddy.
Yes.
Procurement of paddy is not in the determination of this bench. Accordingly, the registry shall do the needful for listing of the matter before the assent. Second matter is here. The appearance of the document, Mr. Mahanti, Mr. B.K. Mahanti for the petitioner, Mr. D.N. Lenka, GA for the opposite party. Yes.
item 4,
So Mahapatra,
Yes, no,
you are Mr. Mahapatra.
no, I am appearing on behalf of
What's your name, sir?
Sibesh Patnaik.
To argue? Mr. Sibesh Patnaik will not argue. Adjournment.
Lords, I am there, online.
Okay, Cordials.
On the last occasion, your lordship had asked me to obtain instructions as to how the petitioner seeks would secure the amount of maintenance.
Sir, this is item.
Oh,
अच्छा आपको 22 लिखा है ये और you are learned junior of
Mr. Panda.
okay yes Mr. Fanda,
my lords. Now, I have taken instructions.
yes please.
The petitioner, my lords, is a paralyzed pensioner, my lords. He is existing on a pension of rupees 16,000 per month.
Yes,
So, if your lordship wants, my lords, that pension amount, my lords, I shall put it and I will die, my lords, if that is necessary.
total kete ଆପଣଙ୍କର due kete helani?
Due is now around 4.5 lakhs, my lords.
So 4.5 lakhs
2019 I have to pay.
future by koni? Future I do not know because I may decide in your favor. How can I say about the future pension?
Exactly, my lord.
So whatever he will secure regarding the 4.5 lakhs due. ସେଥିରୁ ସେ
ସେଇ
କେତେ
ଯୋଉ
କରିବେ?
ପେନସନ ପେମେଣ୍ଟ ହଉଛି ସେଇ ପେନସନ ଟାକୁ ଯଦି କହିବେ ରଖିଦେବି ଆଉ କଣ?
ନା ମୁଁ କେମିତି ସେଟା ରଖିବି? Future installment how can I direct that also? Because if something has accumulated as arrear pension, all right. Say let amount of 4 lakhs has accumulated as arrear pension, then I can issue that direction. But for future, how can I direct? Because and he is.
I don't think there is.
So exactly. So that's not possible also. So let us adjourn it. Let us see.
Yes, let us adjourn.
Mr. Devasis Panda along with Mr. Sorry,
Sibesh Patnaik.
Sibesh
Sibesh Patnaik.
Mr. Sibesh Patnaik for the petitioner. Opposite party blank. The learned counsel the hybrid mode election. The learned counsel for the petitioner referring to the order dated 11/2/2026, 6 for the accommodation to obtain instruction. As prayed for list in the week commencing.
Lord, you may give me second week of March.
सीधा हमारा कोर्ट मास्टर एप्रिल को नहीं लेनी
I आओ.
और एप्रिल चलिबो
आइए. First week of April हो.
6 हाँ से कहले फर्स्ट वीक 6/4
आइए.
तो वीक कमेंसिंग 6/4. Yes please next.
Much obliged.
five,
Yes Mr. Mahanti. एटा काली ऑर्डर हिकला कोर्ट फी ऑर्डर टा ना काली किछि ऑर्डर काली पासो बढितला अच्छा आइए 86 of 2025 हला 5 लेफ्ट मिस्टर आलोक कुमार महांती सीनियर पैनल काउंसिल हला appearance गुड़ाक बेटर होची लिस्ट टिक मार दे so that easier होबा तो लिखियो
No, I am for OP8 man.
just one second. Mr. Prem Kumar Mohanty, Additional Standing Counsel for OP8. The petitioner East Coast Railway. This is statutory, na, Mr. Mohanty?
First of
Because Railways Act. How do you narrate the petition?
our challenge
Railway Act रे कौन East Coast Railway कौन?
East Coast Railway is a party.
ଆପଣ ଯେତେ ମାନେ ଉପରକୁ ଯାଉଛନ୍ତି ସେଟା କଣ ଥିଓରି ମତେ ଦଉଛନ୍ତି? ଆରେ Railway Act ରେ ଆପଣ ଯୋଉଟା it's a legal entity ତାର ଯୋଉ appellant is a legal entity. So it is a body under the Railways Act.
Body Railway.
Or a body cooperative companies act, partnership firm, individual. So that sense I'm asking you.
Partnership firm. It is a
Obviously it is not partnership firm. All of you laugh at me. कौन है सेटा? It's a statutory authority.
statutory authority.
को act सेटा? सेटा अपन लिखी रहती है सेटा ही बात East Coast Railway with a engine and a bogie is a petitioner. Appellate.
No.
सबले लिखी में it is a legal entity. Because that raises the fundamental issue of maintainability of an appeal.
In port below that has been constructed.
Suppose you are evicting a herd of cows from the Patha. You are grazing, you are evicting.
That is right. You are
So then,
because in
the cow owner will come
like port below,
like structure. You are granting structure money for structure and a public, even public premises, you are road also you are granting structure to a dhaba. So how you are granting? To dhaba or the person?
No.
और लिख ले petitioner the appellant petitioner लिखिए आइए अब इतने बोथ लिखिए आइए 86 of 2025 that's ऊपर एले तो हेडिंग है ना तो आइए रे लिखो the petitioner a statutory authority under so and so act सेटा अपन को हम देखी लिखिए East Coast Railway जो थी is in appeal challenging the judgment oblique order dated 21/9/2023. You take your seat, Mr. Mohanty. Let me dictate the order. Both the Mr. Mohanty is read. Judgment and order dated 21/9/2023 passed by the Learned Civil Judge Senior Division Chandikhol, Jajpur, in LA case number 01 of 2009. So, the said LA case was filed under Section 18 of the LA Act, 1894, directing enhancement of compensation of land acquisition award to rupees 10,000 per decimal for the subject acquired property. कितने थिला Mr. Mohanty?
that is 3,000 per decimal.
3,000 10,000 ହେଇଗଲା
10,000.
कौन लिखिए? Per decimal from the awarded amount of rupees 3,000. अरे 10,000 ହେଲା 3,000 3,000. The IE has been filed seeking extension of time to file the court fee. As per the office note put up by the registry. In the meanwhile, e-court fee of rupees 20,985 has been deposited. Accordingly, the IA is disposed of. Mr. Mohanty, what are the grounds of challenge? Then appeal the
Yes, sir. But challenge the ground in appeal, my lord. The referral court has not taken consideration with the land in question is not a homestead land, that is the agricultural land. So the fertility of land should be taken in consideration, and also the distance of the land in questions, how far it from NH. They have taken the NH nearer to the NH.
They have dealt it as a fertile cultivable land or a homestead land. What
Yeah.
they have done.
That is the agricultural land. That is Sarada Dwa fossil.
But but if you make it a homestead, then the cost will increase.
And that is not homestead, my lord. At
No,
the
I am not getting your point, sir.
date of
You are saying instead of homestead, they have made it Sarada.
Sarada Dofosal, status of the land.
Sarada Dofosala instead of homestead?
No, mine.
You are
Only
saying
authorities that converted to the homestead, Garbadi, they cannot be treated. That is treated as a agricultural.
So then you are saying instead of Sarada Dofosali, they have treated it as a homestead land.
They are taking consideration that in future that will be a homestead land. But court bill was a referral court has dealt with that.
There is the valid consideration. The future growth of
Future development.
development is always a valid consideration. ठीक अच्छे बोले तो तेरा complete है क्या दागी इस dispose करो तापरे एल्ले लेखो तू delay कितने दिन अच्छे
400.
तापरे आइए देखिए इटा से आइटा गला आइए 87 of 2025 along with LAA 21 of 2025 है ना Hard Lorded Counsel for the Lorded Senior Panel Counsel for the Appellant. He reiterates his submissions as noted above. He further submits that the Lorded Referral Court has applied incorrect criteria for the category of land to determine the compensation and which has resulted in enhancement. So, issue notice in the IA as well as the appeal. So, requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 7 working days. List after SR, liberty to mention. Then you have deposited the amount.
Yes. That is with protest they have received.
Original award, the 3,000 receive करचो.
Madam.
The IA 6 for what? IA 6 for 2026, sir?
I have restricted for a stay for execution. In meantime, execution has started.
Execution number? 4.
My lord. 4 of 20.
IA number 6 of 2026. The IA has been filed seeking stay of execution. Case number 4 of 2025. Hello? Para. Hard Lorded Counsel for the petition appellant. Appellant petitioner issue notice as above. ऊपर जो लिख रहे हैं issue notice as above. सेठी उधर add 9 add करूँ तो fixing returnable date. आज कितने तारीख को होची? 30 February. Returnable date to 26 March 2026. ହେଲା ते requisite जल्दी दे देवे.
मुझे
26 March 2026. The execution case as an interim measure it is directed. The execution case shall pending before the Lorded Civil Judge Senior Division Chandigarh shall be adjourned to a date beyond your 6/4/2026 upon a prayer being made on that behalf to a date suitable to the Lorded Court in season of the matter.
Yes. Copy.
Urgent certified copy as per rules. Yes, next please. Adjourn date टा आपण करिवे returnable केबे हला
March.
तो ताले week commencing series 30 दिन list in the week commencing 30 दिन. Yes, please.
Item 6.
Item 6 also I'm checking for password after launch my.
Password. So, ठीक है.
7.
May I please your lordship?
Yes, please.
The revision challenging the order of maintenance under section 125 CLS.
Yes.
Husband is before this Hon'Ble.
Yes.
Including order is that Annex 3, my lord.
Yes. Total due. What is the total due amount and how much you have paid?
Total due, my lord, is 1,20,000. As on last month, I had taken instruction.
Total the amount awarded is granted awarded is
3,000 for wife and 1,000 for child.
4,000. Date of application
Date of application is 10/7/2023.
10/7/23. So 10/7/25 is तो 24 मास है तापरे 5 1 6 30 मास 4,000 आउ केते
3,000 for wife and 1,000 for child.
total 4,000.
Total.
This means 1,20,000.
I know.
How you will secure the amount? Have you paid anything?
You take instruction.
You obtain instruction.
When I take. Because I had asked him to pay 40%, 50% to clear up somewhere. Because without my lord clear.
But the problem is that they go for a hard bargaining with for the decree
Sir.
with the lawyer.
I know.
And
Because-
revisional court's jurisdiction is very limited.
Very limited. I had asked him because my lord.
Because he may not pay it, but has to secure it. But it's not a. We must understand that.
I know.
Then ultimately, what would happen? I do not know what is happening. How the court can predict the behavior of the person, that whether he will comply or not.
I asked him to
So
pay.
that is the reason that this law has evolved, that you have to secure the money decree.
Here, my lord.
Mr. Suryasnatha Mahapatra for the petitioner. The petitioner husband in the marriage is before this court seeking revision of the judgment dated 23rd December 2025, passed by the learned judge, Family Court, Bhadrak. In criminal proceeding number 208 of 2023. Stop. The proceeding was, you take your seat, I'll dictate down. The proceeding was initiated by the wife in the marriage along with minor child, represented through his mother under section 125 of CRPC into brackets since repealed and substituted by perimeter provision contained in section BNSS 2023 bracket closed, seeking monthly maintenance of rupees 15,000. Stop. So the application was favored by the learned judge, Family Court. However, granting maintenance to be paid by the opposite, the petitioner husband in the marriage at the rate of rupees 3,000 for the wife and rupees 1,000 for the child. In view of the judgment rendered in Ratnis versus Snehas, para so and so, the amount directed to be paid to the wife in the marriage as well as the child born from the wedlock is in the nature of a money decree. Into bracket para so and so SCC print. Chota debe INS achi apan so goda apan both SCC rakchu. Yes. SCC print. Bracket closed. The learned counsel for the petitioner was asked whether the petitioner has paid any amount and to challenge the direction for payment, how he will secure the amount. Stuff 6 and has adjourned this in the week commencing.
March last, April 1st.
Week commencing 6/4/2026. Execution is pending.
No, man. Not in.
Yes, next please.
Please your lordship, my lord, I am BCR Puri, my lord. Here
Yes,
the important adder, that is the Lord Judge Family Group Puri, under section 184 BNSS Act, 2023 has been challenged. As because, my lord, only I have challenged only two counts. The first count is the quantum and second count is the date of application. Because the Law and Trial Court passed order with effect from to be paid the maintenance dues with effect from 3/9/2024 instead of date of the order, my lord. That is the date of application. And
Sir,
another is the quantum.
Sir, which, are you sure that you are stating the correct proposition of law? I will record and reject it. It has to be from the date of application. Supreme Court direction.
My lord, I pray before your lordship, my lord.
I also pray that you please follow Supreme Court.
My lord, I pray only.
I also make I can pray. I hope and pray, of course. So the opening statement you are making with being responsible officer of the court is wrong.
If your lordship will permit, I
Start
just
recording them. Then the only prayer would be that something will prevail upon me to do justice. It has to be from the date of application. It cannot be.
because it is not a year-old case. That's why I pray, my lord. It is very early. It is not a year-old case.
Sir, you have started adding lines to the Supreme Court judgment. That is still more unfortunate, and that is another prayer. Please don't add a year case. No, from another date. New case from another date. There is no such distinction. The reasoning is very simple also. The date the person approaches the court, that date. That's it.
My lord. So, however, the quantum has been challenged because, my lord.
So you challenge. It's a very good thing that you are challenging the generating more litigation. Good for the system. But please secure the decree.
My lord,
That is the third prayer.
my lord, only on the ground that the husband is married in patient, my lord.
Very well, sir. Very well, you secure the decree.
My responsibility.
What is the total? What is the amount of it?
Total amount 10,000 awarded by the family judge Puri, my lord.
Total 10,000.
My lord. And husband is a bedridden patient having the cancer patient and undergo treatment, my lord. I have annexed the document before the trial.
Sir, I cannot reopen. That is a fourth prayer. That in a revision application, the Supreme Court has said that the High Court cannot have a different view.
My lord.
It is based on the evidence.
Revision par, supervision par, I know, my lord. I know, my lord. That is the supervision par.
Revision is very. Which is the decision?
I pray matter may be admitted and notice may be go.
I also pray that don't address to make illegal orders. Admitting a case without securing the decree is an illegal order.
No, my lord. Madam, however, the revision may be admitted and I must have given
admission. No admission, it will be dismissed. If you are serious, I will dismiss it today only. I can spend time like this.
No, my lord, I only
running after judgment to secure the decree. I can't run around. You must understand that. I don't have that luxury of running around the judgment debtors that kindly secure the decree.
My lord, I pray, my lord. At least for a reappreciation.
I also, is it not that I am praying you? I am also praying that you secure the decree. For dismissal, I don't require any of your prayer or my prayers. That's the law.
My lord, I pray another number be given. I will satisfy your lordship, my lord.
No, but it's not a question. Satisfaction of the not. I am very satisfied today. Most satisfied. Auspiciously, I am very pleased. So kindly secure the decree, or if you make a statement not to secure, I will record and dismiss it. This is your choice.
I will secure the decree. I have admitted my lord.
Yes. Secure the decree.
I secure the decree. Though I am preferring the revision, that's why I pray, my lord.
Yes. For preferring revision, you have to secure the decree because you don't pay, you will receive the money with interest.
No, my lord. That is not.
And maybe they will be giving more interest when court direction is there, like senior citizen scheme.
My lord. Only husband bedridden patient. That's why I pray, my lord. Nothing more.
The bedridden patient before the trial court is I cannot resurrect. If he is standing before the trial court, I cannot make him bedridden.
Sorry, but I believe that I have taken.
I am not the magistrate. I
have taken that plea before the trial court also.
I cannot revisit. The facts.
My lord.
14 ମାସ 1,40,000 डिपोजिट करिवे ना डिसमिस करिवे
ଏ ହଜୁର ଅର୍ଡର କରନ୍ତୁ ପାର୍ଟଲି ପେମେଣ୍ଟ କରିବେ ସବୁ
ନା ମୁଁ ପାର୍ଟ ଆଜ୍ଞା ମୁଁ ଏଠି କଣ ସେଠି ମାନେ ଇଏ ଏଜେଣ୍ଟ ଆପଣ ନା କଣ ଏଠି ପାର୍ଟ ପେମେଣ୍ଟ କରିବେ ଆପଣ 1,40,000 डिपोजिट करिवे ସୁଧ ସହିତ ନେଇକି ଯିବେ କେସେ ଜିତିବେ ଏଠି ଆଜ୍ଞା ଦିस इज नॉट ए बार्गेनिंग प्लेस
ସରି ମାଇ ଲର୍ଡ ଆଇ ଏମ୍ ଏକ୍ସଟ୍ରିମଲି ସରି ଫର 50% ପ୍ଲିଜ
ସେ ଆପଣ କଣ କରିବେ ସେଟା କଲ ପରେ ସବମିଶନ କରନ୍ତୁ द लर्नेड काउंसिल फॉर द
I take instruction, my lord. from
yes
the
yes
client.
of course
My
I am not discussing any matter for that so you have a execution हेला ना नहीं
No execution has been started, my lord.
ठीक আছে तो अपन କିଛି ଅସୁବିଧା ନାହିଁ ତାହେଲେ କାହିଁକି ଏଥିରେ ବାର୍ଗେନ କରୁଛନ୍ତି କାହିଁ ଡିକ୍ରି ବାର୍ଗେନିଂ ଏଟା କଣ ଡିକ୍ରି ବାର୍ଗେନିଂ ପ୍ଲେସ୍
Hey, sorry, my lord. I take instruction for a client. that's
I'm
why.
I'm really sorry sir I have to address you on these points
Only I take instruction.
Mr. Tilochan Panigrai for the petitioner the item कितने इधर actually 8 so Tilochan Panigrai for the petitioner opposite party blank the petitioner husband in the hand on counsel for the petitioner who is present at the virtual court High Court of Orissa Puri had on counsel for the petitioner at length which present at the virtual court High Court of Orissa at Puri stop the petitioner husband in the marriage is before this court seeking revision of the judgment dated 29.01.2026 passed by the Lauded Judge Family Court Puri.
My lord, both husband and son, my lord. 2 persons are there.
ये रुहतु आपण भिसी रहले बदे आपण डिलीट
Sorry.
कौन हस्बैंड कहलेनी कौन सन कहले कौन लिखी ଆପଣ ଦି ଜଣ ଯାକ ମାନେ सन एंड हस्बैंड ଦି ଜଣ ଯାକ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି
My lord.
कौन लिखी the husband in the marriage as well as the son of the opposite party are before this court seeking revision of the judgment passed by the Lauded Judge Family Court Puri in CP number 103 of CRP in CRP is 103/2024 judgment जो लिख लेनी dated 29/1/2026 The CRP number, the said CRP was filed by the lady, aged about 63 years, the wife of the opposite party number 1. The marriage having been solemnized on 22/11/1981, and her son seeking maintenance under the provisions of 144 of Bharatiya Nagarika Suraksha Sanhita at the rate of rupees 40,000 per month. It is stated in the petition before the Learned Judge Family Court that Groupie number 1 husband has a multi-storied building and shop at Daraji Pokhari in the Puri town. and the OP number 2 into bracket petition number 2 herein works in a private job earning 2 lakh per month. That peremptory, either you deposit 240 or I will dismiss it. No bargaining, Mr.
I take instruction. That's why.
Yes. This has been made actually really the sad state of affairs. No semblance of respect for law, only greed and personal vendetta. Personal grudge. And now I will make a lady about aged 63 years, then now 64, run around the courts by issuing notice, despite observations of the Supreme Court that these matters should not be kept pending. All likely? Last opinion Major under a party?
My lord.
The 10,000 କାହାକୁ ଦେବା ପାଇଁ କୁହାଯାଇଛି?
ଦି ଜଣ ଦେବେ।
ଏ ପଢିବେ ପାରା 19 ପଢନ୍ତୁ।
ନାଇଁ ସେ ଜଜମେଣ୍ଟଟା ହଉଛି ପଢୁଛି ଖାଲି ଅର୍ଡର ପର୍ସନ ପ୍ଲିଜ ଲେଖା ହେଇଛି କଥାଟା।
ପାରା 19 ରେ ଯାହା ଅଛି ପଢିବେ ଆପଣ କଣ ପଢିବେ ଆପଣ ଜାଣିଥିବେ।
Admittedly, the petitioner has one son and 2 daughters. The OP number 2, being the son of the OP number 1, is managing his family business. He is also taking care of the landed property of the OP number 1. The OP number 1 has already transferred the ownership of his land in favor of the son of OP number 2. It is not specifically stated by the OP number 2 that no sub house is given on rent and he is not collecting any rent on behalf of the OP number 1. The OP number 2 has the wife and a child who are his dependents. The OP number 1 is now suffering from kidney cancer. He has the previous earning, saving and assets. So the OP number 1 may not be treated as a dependent number 2. So the considering the expenditures of the petitioner for her maintenance and for her medical expenditures due to old age, and as the OP number 2 has the liability to maintain his wife and child, he is directed to pay 10,000 per month to the petitioner from the date of the
कोटी डायरेक्शन OP number 1 को दवा ପାଇଁ
order portion हजर थिला हेथिं को
आया कोन आपण कहउचली मु बुझी पानी मु पचारची OP number 1 को कोटी डायरेक्शन अछि टंका दवा ପାଇଁ why is it directed to the OP number 1 to pay amount कोन लिखे OP 1 has a materiality job and OP 2 is only to last para the application was favored. However, directing the OP number 2 son in the petition to pay rupees 10,000 to his mother. Considering the condition of the stop mother, stop. Apparently the learned judge has taken note of the condition of the OP number 1 before him and only directed OP number 2 to pay the amount. In view of the judgment rendered by the Honorable Apex Court in Rajneesh versus Neha, the amount directed by the learned judge family court to be paid by the OP number 2 to son to his mother is in the nature of a money decree. Stop. Challenging the same as per the provisions contained in the Civil Procedure Code and also the directions of the Apex Court in Rajneesh versus Neha, paragraphs into bracket, paragraph dash to dash, Rajesh Nechantiya of SCC, bracket closed. The petitioner seeking revision, petitioner number 2 seeking revision has to secure the decree before this court. The learned counsel for the petitioner upon instruction submits that the petitioner number 1 or 2 have not paid any amount during during pendency of the proceeding or for challenging the amount before this court. He has adjournment to obtain instruction from the petition number 2 to secure the decree before this court for sustaining the challenge. List in the week commencing. Mr. Panigrahi.
My lord.
Panik kebe asibo?
2 to 3 would be granted, my lord.
In the week commencing 30.
My lord.
33 20 26.
My lord.
Yes, next.
Item 9 টা pass করুন।
ঠিক আছে।
Item 10.
Yes, please.
So before my lord,
Mr. Abhilas Misra for the petitioner.
the wife is seeking for transfer of civil proceeding initiated at the behest of the husband from Sambalpur to Sonpur.
She has filed the petition or the husband has
Husband filed.
Take
Yes.
notice.
My lord. I filed an I for stay, my lord, for the proceeding.
So Abhilas Misra, देख लेना। अब लिखिए the petitioner wife in the marriage. You take your seat. I'll take down. The petitioner wife in the marriage is before this court seeking transfer of the CP number 205 of 2025 pending before the learned judge family the learned judge family court Sambalpur to the court of the learned judge family court Sonpur.
My lord.
Sonpur. CP number ta pakele. CP number 2025. No. The said CP has been filed by the opposite party herein, comma, husband in the marriage. Under various sections of the Hindu Marriage Act, read with Section 7 of the Family Court Act, seeking dissolution of the marriage. It is submitted by the learned counsel for the petitioner, had learned counsel for the petitioner, issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within how much time?
14 days.
Within 5 working days. Within 5 working days. List after SR. Liberty to mention. You issue notice लिख लेने की. The returnable date be fixed to 25 February 2026.
March, my lord.
2026. No, sorry, 25 March. Yes, right. 25 March 2026. 25 March 2026. List in the week commencing. Actually, date न कल असुविधा कौन होती? List after SR liberty to mention. The date कर देवे.
My lord, date no go असुविधा हो कारण date implement जो
Okay. List in the week commencing 30/6/2026. As an interim measure, it is directed that the CP number so and so pending before the so and so shall be adjourned to a date beyond 6/4/2026 to a date convenient as would be convenient to the learned court in season of the matter. Upon a prayer being made by the petitioner. Liberty to mention? Yes.
11.
Lordship, in this case,
Mr. Senapati.
yes,
Mr. Lambit Senapati for the petitioners. Yes.
Lordship, in this case, the petitioner filed this transfer petition seeking transfer of the CP 84 of 24 from Judge Family Court Hon'Ble to Judge Family Court Bhubaneswar, Lordship. The Lordship. In this case, the biggest difficulty that the present petitioner has been facing is that the present petitioner is at present working in a bank at Pune, Lordship. As a result of his, he has to travel a lot from Pune to Bhubaneswar and from Bhubaneswar to again to Hon'Ble. And Lordship, in the second part is Lordship, at the present opposite parties at present are also living in Bhubaneswar, Lordship, which has been also admitted during the cross-examination.
How does it help you in transferring the matter?
Lordship,
Because he is staying in Pune
yes, Lordship.
or anywhere, maybe US or anywhere he is staying.
Yes.
How does it help that to transfer
Because
the prayer is to be made wherever of his choice? That cannot be.
no, Lordship. What I am praying, Lordship.
So you, if you want to use the ICT facility, you use.
Lordship, what I let notice be issued because at present both
No,
the
no.
parties are presently residing in Bhubaneswar, Lordship.
Sir, you are not the spokesperson for the. Then you have to record
I
that
beg- I
since
beg-
the petitioner is the
I
spokesperson
beg pardon.
through his. So I beg pardon. I am asking you a question. Are you the spokesperson of the opposite party?
No, Lordship.
So then why you are making that submission which is to be rejected?
I beg.
Suppose I record that. Can I?
No.
Then
What if?
because the husband comes to the court and says something, the court has to believe that or what? What is the criteria of if they are staying in Bhubaneswar? Can the court is it something to be justiciable? Then make some submission which is relevant.
Yes, sir. The
He staying in Pune doesn't improve the case being at Hon'Ble or Bhubaneswar.
difficulty.
And the difficulty, the most difficult part is that if it's a matter of 24 in Hon'Ble becomes matter of 26 at Bhubaneswar. And expeditious disposal is very difficult in Bhubaneswar because of the case overburden.
Well, Lordship, anywhere nearby it's also doesn't because
Why nearby?
he has to.
How can I don't have jurisdiction to transfer the matter to Pune? What do you mean by nearby?
Nearby
How
means
Bhubaneswar?
in Bhubaneswar.
How Bhubaneswar is near to Pune? Then what is this logic?
I beg pardon. What if?
Why you are begging pardon so many times? I don't understand.
What is?
You have to answer some query. My queries are not to. I am not seeking any pardon from anyone. Why should you? I am asking you a question after you have submitted. You are saying for a person staying in Pune, Bhubaneswar is convenient. How can I dictate that?
It's
There a person who works at Pune, the Bhubaneswar is the most convenient place, Hon'Ble is not inconvenient. How can it be then? Why there are 30 districts in Odisha and why there is a jurisdiction clause section 19 in Hindu Marriage Act?
So, Lordship, what is submit, Lordship? As because it's getting difficult on his side on the behalf of the petitioner from traveling from Pune to Bhubaneswar and again from Bhubaneswar to.
Have you ever traveled from Bhubaneswar to Hon'Ble? Have you ever yourself traveled?
Yes, Lordship.
So what is the time taken?
It's like 2 hours.
Then
That's a big.
then there should not be any case anywhere other than Bhubaneswar for persons working outside. There should not be any case, and then why section 19 is there, which is the provision section 19 that depending on the convenience of the husband, it has to be filed.
No, sir, no, sir. That's
No,
what I submitted.
no case is made up. No case is made up.
Presently, his wife is also residing at Bhubaneswar. So,
Sir, you are confused for whom you are arguing. I'll record and reject it.
no. What I submit, let's give a short pass.
No, I have to record. This is not a matter of to make fun.
No,
You must understand.
I
At least I am sure that I am not having a fun time here. That everything I will entertain and I will not pass any order.
take instructions, short adjournment will be given.
Yes, you take adjournment, no difficult. But I'll record your submission. Yes, anything else or you are satisfied with your submission?
I just need to take because the difficulties was as
I cannot, sir. I cannot dictate that the Bhubaneswar court is the most convenient in Odisha.
no.
Must understand, I am a supervisory court.
Give a short adjournment.
Because then every case where the person is staying outside has to be at Bhubaneswar, then what about other 30 to 31 districts? And also, in fact, everywhere it can be initiated. It is not necessary family judge should be there. It can be a civil judge senior division. Say place like Athawad. Cuttack it is family court. In Athawad it is civil judge senior division.
Yes.
So what is this logic of saying that how can I dictate that? I must derive strength in my order.
So I give big pardon. Also give a short adjournment.
So possible. No, yes, it will be adjourned, but I can't ignore your submissions and just leave it like that. I had Mr. So-and-so lecture the hard order counsel for the petitioner. You take your seat, I'll dictate the order. The petitioner husband is before this court seeking transfer of the CP number 84 of 2024. From the court of the judge, family court, Hon'Ble. The court of the learned judge, family court, Bhubaneswar. What is the amount due? Interim maintenance amount?
It's in the stage of cross-examination of witness, Lord Sir.
Sir, are you following the question?
Yes, Lord Sir.
What is the amount due of interim maintenance directed and due?
So that till date, as per my instruction, Lord Sir, as per the instruction I got, there is no interim maintenance has been
Directed by the court. I'll record that.
Yes, Lord Sir.
Yes. Alexa? The said CP has been filed by the wife in the marriage along and the minor daughter, minor child, minor girl child born from the wedlock. Take your seat. Under sections 18 and 20 of the Hindu Adoption and Maintenance Act, 1956. Seeking monthly maintenance of rupees dash per month. The amount of the salary received by the petitioner herein has been stated to be rupees 70 lakhs per annum, as he works in. What is his designation in ICICI Bank?
Right now, I'm not.
Sir, then at least you must understand what you are doing in the court. You do not know anything about the case, anything about the petitioner. You must expect this question when you are challenging, seeking transfer of a maintenance application. What is the amount interim maintenance awarded?
Let me give me one time.
And the petition has been filed stating that it has been filed before the learned judge family court stating that the petitioner herein has failed to provide financial support for child's education, healthcare, daily living expenses. जो अमाउंट लिख लें 50,000 per month. It is submitted by the learned counsel for the petitioner that the petitioner working at Pune, it becomes Pune in the state of Maharashtra, finds it more convenient for him to prosecute the matter at Bhubaneswar. As from Bhubaneswar, he has to travel to Hon'Ble. In considered opinion of this court, this contention is contrary to the provision of law which gives freedom to the lady and child who are petitioners before the learned judge family court Hon'Ble. Have you examined the provision where it provides territorial jurisdiction? Anyway, you take your seat. Para. On being asked whether any amount has been directed to be paid as interim maintenance, it is submitted by the learned counsel for the petitioner upon instruction that no such direction has been issued for payment of interim maintenance during pendency of the petition before the learned judge, family court. The learned counsel for the petitioner has adjournment. Make further submissions as to whether for filing a application under section 18 of so and so act the convenience of the husband, who is also the father, has to be looked into by this court. Yes, next. List in the week commencing. Yes, Mr. Senapati.
Any date not, sir.
Any date is not available.
No, sir.
It starts with 1, ends with 31st.
Second week March.
Week commencing.
Is it a
23, Yes, next. Mr. Yes, Mr. Das.
Madam, the petitioner is telling the order dated 24 December 2025, madam, granting interim maintenance to the petitioner, madam. Petitioner is the wife, madam. Petitioner and his only child was staying with the petitioner, madam, in a rented house at Bhubaneswar, and they are not getting maintenance. They claim interim maintenance for the Judge Family Court Sambalpur under 24 of the enumerated, madam. Even though the judge, honorable judge has mentioned in his order, madam, that the asset liability certificate is not filed by the husband, madam, nor any income affidavit is filed. And he is working a managerial post in Hindustan Petroleum Limited, Mundra, madam, getting 2 lakhs per month. Only 20,000 interim maintenance is granted. I am challenging that.
You want enhancement of compensation?
Yes, madam. That is my plan.
Mr. Ashwini Kumar Das for the. To take your seat, I will dictate the order. Mr. Ashwini Kumar Das for the petitioner. The petitioner wife is before this court. Seeking enhancement of the maintenance, enhancement of the interim maintenance awarded by the lauded judge, family court, Sambalpur, in IA number 16 of 2025, arising out of CP number 83 of 2025. Stop. The CP number 83 of 2025 was filed before the learned judge, family court. Who has filed the CP, sir?
The husband.
Husband. 13.
30.
Under section 13 of the Hindu Marriage Act, seeking resolution of marriage solemnized between the parties on 101.03.2013. During pendency of the CP, maintenance pendentellite under section 24 was sought for, and an amount of rupees 20,000 has been directed. So, para it is submitted by the Honorable Counsel for the petitioner that considering the income of the opposite party husband in the marriage and the cost of living that has to be borne by the petitioner, the amount is not adequate. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. List after SR, liberty to mention. Para, they don't seek stay in these matters. You do not. Para, it is further directed that petitioner shall continue to receive the amount awarded by the learned judge, family court by order dated 24/12/2025 in IA number 16 of 2025, into bracket arising out of CP number 83 of 2025. Bracket closed, without prejudice to her rights and contentions in the present application. Yes, next. Yes, Mr. Verma.
Please, your lordship. Your matter, the challenge is the order at annexure
Mr.
33.
Verma's matter. Your is 14.
Sorry, sir. I'm sorry.
Yes. Mr. Pradipta Verma for the petitioner. Yes, please.
Well, the petitioner has challenged the impugned order dated 16/2/2026 of the London Family Court Judge 2 Bhubaneswar, whereby the London Family Court has allowed the application for recalling the PW1, that is the petitioner, at the fag end of the trial, my lord, after the trial or the hearing from both the parties were over. Well, that, my lord, basically I have challenged this order basically on 3 grounds, my lord. First, my lord, as per the laws settled down in the judgment of the Rajesh versus Neha, well, there are other provisions of if there is any discrepancy found in the affidavit, that disclosure affidavit, there are other remedies which the respondent has availed, my lord. That is by asking for a set of interrogatory and asking for documents and getting all the details, my lord. The second, my lord, there is no, as I already said, there is no provision of recalling the petitioner for the specific purpose of examining or interrogating him, my lord. And third, my lord, despite the fact that, my lord, there was a clear-cut instruction from this Hon'Ble Court, there is an order of this Hon'Ble Court dated 8/12/2025, my lord, to conclude the proceeding of this case by end of this February, my lord, because the matter is pending since 9 years. And the petitioner has concluded his evidences since 2023, my lord. And for the last 3 years, my lord, only to examine two witnesses of the respondent, they took 3 years, my lord. Still, and my lord, this this affidavit of asset and liability, my lord, that was filed in September 2024. My lord, all the 1.5 years, my lord, the respondent did not find it suitable to call him in case it was available to him. And after her evidence was over, my lord,
can you give me some dates? When the affidavit was filed?
My lord, 24/9/2024. My lord, I have in the list of dates.
24/9/2024.
My lord.
By the husband, asset and liability.
My lord.
Then wife has filed asset and liability?
In January 2025, my lord. Exact date, my lord?
No, not necessary. Tentative sequence of events I want to understand.
What happened?
What is the date of examination in chief of husband?
That was in 2019, my lord.
2019 examination in chief of
husband, my lord. And it was
cross examination?
My lord, 12/4/2019, petitioner filed his evidence affidavit, and evidence it continued
12/4/19.
12/4/2019.
Evidence affidavit. By the husband.
By the husband.
Yes.
Well, there was some delay due to this COVID-19.
Sir, I'm not.
It was concluded.
Please don't be apprehensive that I'm thinking about the delay. I want to understand the sequence. So there may be delay, but there is always a direction. So 12/4/19 evidence affidavit. 24/9/2024 husband files
asset liability.
So how do you say that it is prejudicial to you? I don't understand how do you say that recalling the witness is prejudicial to the husband.
What is that?
Because now then I have to give a finding. I have to give a finding, reasoning rather. The finding, to be correct, what would be perhaps reasoning? That 24/9/2024 affidavit was taken note of or by confronted by the other side. Because I cannot do that.
No.
Suppose now then only thing you can say, when they are recalling the witnesses, the earlier deposition of pertaining to 12/4/2019 affidavit shall not be repeated. Because that also you can do as a lawyer. Simply saying, but I can only highlight it now. As far as 24/9/24 affidavit and one this January 2025 affidavit, there are 2 affidavits now. As far as they can appreciate this. So now suppose there is no further examination of either of the witnesses. You have also liberty. Because now suppose you want to examine the wife. I now refuse recalling of the husband. Same thing, the wife will take the plea. Then how does it benefit you? I don't understand this.
Although both the sides evidence has been closed, my lord.
Correct. But after Rajneesh versus Neha, since it has been mandated that for any kind of adjudication, though it is not mandatory, but it is being followed. In the Odisha High Court, some decisions were said that Rajneesh versus Neha seeking an affidavit is only a guidelines. Division bench, I'm sitting with Justice Sinha also. And I think reading the judgment also will find that it is not directory that way. It's not mandatory. It is more kind of directory. Now, Rajneesh versus Neha has been complied with. After completion of Rajneesh versus Neha, you want to examine the wife. I'm asking for your part. She files in January 2025. You can examine her.
Well, what has happened?
Now, how can after direction of the Supreme Court, this court will say, you can say that whatever has been examined, whatever evidence has been laid or chief has been done, cross-examination, those things the court will not allow to be reopened. Fair enough. So that I'll clarify and dispose of. But I cannot say that he can be recalled.
Why?
Then at what stage? Then at what stage this affidavit can be confronted?
No, my lord, there is a procedure, set procedure of the Honorable Supreme Court, my lord. I may be permitted to read that, my lord. And why this affidavit, this disclosure affidavit of asset and liability was there? That is precisely...
You read and reread.
My lord.
You read and reread Rajneesh versus Neha where Supreme Court has laid down the guidelines.
My lord.
Regarding non-examination, the Supreme Court has never said either the husband or the wife cannot be examined. Because the problem is then you are making the affidavit partly redundant. Unless the contents, you see to what extent what is happening. This court I have seen sitting in division bench. A person says that I am a graduate. He is an engineer, he works in Vedanta. This court has to send a notice to Vedanta. They appear, they say that he was working through a kind of a contractor or an outsourcing agency. His salary is this. And you please mark the last part of the affidavit of the Rajneesh versus Neha, what it is said. It says that I swear that these are correct. Any part found to be false, I shall be prosecuted for perjury. Even then also it is being false. The same thing applies to wife also. I am not saying it is gender specific.
Still there is a remedy, my lord, in the guidelines. Well,
because as far as trial is concerned, when if I injure the court from, you may say that those examination which has taken place, because you said you could not give me the date actually, those I asked you.
No, which date, my lord?
I followed that date of examination in chief and cross examination of the husband, who is the petitioner here.
My lord, the examination in chief was between, my lord.
After affidavit, it has to be after 12/4/19.
Yes, my lord. My lord, what I have given, my lord?
So the asset liability affidavit is 24/9 to 2024.
24 men.
So how the court?
It was after that. Yes.
5 years. Same thing for the.
My humble submission is, my maybe permitted to submit, my lord. Well, there is a clear-cut guideline in that Honorable Supreme.
You have to tell me. I'm telling you seriously. If the Supreme Court has injuncted the trial court not to examine, then I will pass that order. If it has, because I have read and reread Rajneesh versus Neha.
No,
your contention on the face of it is incorrect. Your contention is that due to Rajneesh versus Neha, the witness cannot be examined.
No, I have never said that.
You are suggesting that.
Well, I am only saying.
If the court decides, if the trial court decides how the High Court will injunct the trial court, intervene and say that no, you can examine.
When, my lord, what my submission is, when everything, my lord, because on the details of the husband regarding his income and everything, he has been cross-examined.
I will cite that decision where I have directed that the Vedanta to, you see what is happening. Now suppose you decided, how does it help you? The same thing will be examined here again, the set question will be raised before this court. It becomes a endless saga because of this thing. Rather, it will be prudent on the part of the husband that once for all, this should be closed there.
He has,
because suppose now the whatever was asked in on 24/12/2019. I mean, whatever may be the date, you are not sure. I am not asking that, but what I have understood. And you have very fairly said that it was 24/19. 25 is the affidavit. After filing of the affidavit, how the court will conclude without examining if the other side, now the other side may not. Other side may ask questions.
1 minute.
So now, and why you are not examining the other side?
No, I have already examined.
So
I have already, because
25, after 25.
25, because they have not filed their evidence affidavit, because with the evidence affidavit, I have examined her and cross-examined.
No, I am not talking about as a lawyer. I am talking about as a principle of what you call litigation. Standard principle of litigation. Wife has filed affidavit, you examine, no difficulty. So now suppose it is not that they have a freedom to only one-side it.
No,
so that's also you must understand.
My humble submission is that asset liability affidavit is only for the purpose of determination of the court regarding the interim maintenance.
The person who are working in Vedanta as engineer states in affidavit. I am a graduate.
I was there also in the court also. I was there.
I have seen that. And that fellow, then they resigned. He went and joined at some court, some place as a supervisor. This becomes an endless saga, mister. It becomes a headache for the lawyer also.
Let me hear the question.
Do you think that it is largely for the client to mislead the lawyer? At least this defect will be hunting your client for the entire litigation.
If he doesn't come,
obviously. So now, because now it is on board. They have filed the application. I injuncted. Rather, I say that no, don't examine him and proceed. The same plea will be taken in the MATA. Same plea will be taken in the Supreme Court. So how does it help you? And also your anxiety to the extent that after long filing of the affidavit and cross-examination examination in chief and cross-examination, they should not recall a witness. Correct? But because of, I think Justice versus Neha was not there in 2019. That is another problem.
It was not there.
That is another problem.
Yes, ma'am.
So you have to harmoniously and conjointly read the entire scheme what has happened. These things will not happen after Justice versus Neha, where it has become part of the routine procedure. Asset and liability was not there in 2019.
It was not there.
So then that point also I cannot answer while deciding. Suppose I say that he cannot be examined. I am taking the best case scenario for you. That the trial court should not have recalled the witness. But in 2019 it was not there.
No, that is, he has already exhausted his remedy by putting an interrogatory of 29 questions and also applying before the court to submit the documents, which I did that in October and November. But when this honorable High Court passed the order, they finished the matter.
Application that they gave.
Page.
It doesn't help, mister. It's a Burma. You have to have a broader.
Yes, my lord. I don't understand.
Prime Minister, your point is well taken. That 2019 is the chief evidence affidavit. He has been examined. There has been cross-examination. Then why now recall?
No.
But now after in fact, the senior counsel is now there. In her case only, that Vedanta, she was appearing for the wife. It happens.
It happens.
I mean, the persons are with impunity are filing affidavit, and they don't, which will not withstand cross-examination or withstand judicial suit. I mean, they are sitting for suit. Lawyer cannot do also anything.
My lord, yes. The application, page 37, my lord. Petitioner to recall PW1, namely Samrit Naik, for the PW1, Samrit Naik has filed his evidence on 12/4/19.
So, Norma, I was reading with you the brief. It's not that I have prepared independently. The para 2, how this court will overcome. Kindly read para 2.
Well, para 2,
you can read para 1 also.
Has filed evidence for 12/4/19.
PW1 has filed his evidence on 12/4/19. Subsequently, he was cross-examined and discharged by the Honorable Court. So, to that extent, they are fair. They concede. Actually. then para 2 is important.
And that the petitioner, namely Samit Naik, has filed his asset liability affidavit on 6/9/2024. As such, the respondent did not get a chance to cross-examine him on the point of asset and liability filed by him. Well, here I am saying,
So here only para 2, I will clarify that only para 2.
well,
Your point is well taken that after 2019, after his discharge,
well,
he cannot be re-examined.
I have never said that. I have never said
Correct. Regarding that affidavit,
well,
regarding that 12/4/19 affidavit, he should not be also.
well.
Then that amounts to
No, I am never on that. Only my submission is this asset liability affidavit is for ascertaining as a temporary basis for the interim relief only.
Maybe someday Supreme Court will lay down that High Court. I will be really reluctant to as far as para 2 is concerned, but I will only say this much that it has to be strictly confined to para 2 only. Para 2 and all objections on behalf of the petitioner regarding para 2 in case of cross-examination have to be taken note of.
One more aspect, my lord. The respondent knew that the matter is need to be ended by end of this December. So
that is an administrative side. Because strictly speaking, the court should not interfere and target Constitution bench decision now. And now, Constitution bench after that, Justice Oak has said that what the High Court should not do by fixing targets is doing daily. And the language is to this extent the Supreme Court has gone. Part 3 of Constitution bench ACM is surfacing. When that they have modified that order, stay should be vacated within 6 months. So these aspects have been considered.
Because 9 long years, my lord.
And no, but at least now in this process, I will be delaying the whole thing 9 years, then 10 years. Because para 2, I cannot give a order that para 2, as far as recall of the witness is concerned regarding affidavit dated 6/9/24.
One more line, my lord. As because the respondent, the petitioner is residing and working in UK, my lord. So he has to come and
that ICT, whether the court will permit whatever that information and communication technology facility, VC, everything.
My lord.
So, or when he comes, his convenience should be looked into. That application you have to file there. Suppose you come here that they are not granting that, then I have to interfere. Because that's a very reasonable prayer. And in most cases, in this kind of where interstate, Supreme Court is taking up. They are allowing remote. But the problem is in a foreign country, how to ensure that because the method, the procedure is different there. For as far as India is concerned, fine. Even if from another state, one can appear in VC. But from another country, what are the I express my ignorance regarding that.
My lord, there is a procedure, my lord. He has
for foreign country or go to this embassy.
The embassy and
whatever is there. No, even if you apply for that, I can only make a pious observation that if he applies for that, that shall be considered and allowed.
My lord, I am only asking if he comes here, my lord, in one day he may be disposed because the respondent.
One day I do not know.
Otherwise, it is adjourning for another month and again it will continue.
That I'll observe. That I'll observe because you have to make I cannot presume that the court will behave irrationally. Must understand that. I can make an observation regarding that. Yes, Mr. Prasad, anything left? Nothing. Rather you interjected his, you diverted his attention. He's on track.
That's why I'm giving the text when my lord score is there. But
no, he's not sure, but he's saying that it is definitely prior to that fact. Paragraph 1 is correct. Suppose now they missed the opportunity of examining after filing of affidavit, then it's a different fact scenario.
May be permitted to withdraw at this time.
No, I'll record this and then I'll permit it to withdraw. But if you withdraw, then how can you make an observation regarding foreign that?
No, I'm sorry.
No. It's up to you. You can withdraw. No difficulty. Why should I compel you?
Without any prejudice, I may be permitted to withdraw.
Okay. Kindly find a memo. The car is leaving. The application under Article 2, appearance section, so Pradipta Verma, for the petitioner opposite party blank, you take your seat, I'll display the order. The petitioner, so no observation regarding that, that since he is staying outside, so he should be accommodated in continuous.
My lord, this matter may be disposed of.
Maybe if you apply for that petition, the problem is that then, okay, when they reject it, then you can move again. Why don't I can't say that. It is your choice.
My lord.
Yes, you take your seat. I'll dictate that. The petitioner husband in the marriage is before this court. Challenging the order dated 16/2/2026 passed by the learned judge, Family Court Roman 2, Bhubaneswar. So, by the said order, the petition dated 11/2/2026 filed by the respondent wife before the learned judge family court in CP number 80. But actually CP number 76 of 2017. For recall of the witness, recall of the petitioner as witness in the proceeding was allowed para. The ground for seeking the recall of the witness is clearly stated in the petition filed before the trial court at paragraph 1 and 2, which states thus. The page Annex 4, page 37. It is submitted by the learned counsel for the petitioner that the evidence affidavit on behalf of the petitioner was filed on 12/04/2019. And after his cross-examination, he was discharged by the learned judge family court on 12/4/2019. And there is no justifiable reason to recall the witness. After advancing arguments for some time and after deliberations regarding the recall of the witness, after filing of affidavit dated 6/9/2024 indicating the assets and liability as directed by the Hon'Ble Apex Court in Rajnesh versus Neha. So and so. The learned counsel for the petitioner files memo of date, which states thus: the memo is taken on record.
No, my lord, maybe we reconsider. My lord, I may not be. I may not file this memo for withdrawal. My lord, maybe, my lord, whatever I was saying, maybe dispose of with a observation. My lord. I'm sorry.
The reasons that has persuaded the learned trial court, learned judge family court, to allow recall of the witness is that the assets and liability affidavit on behalf of the husband petitioner was filed on 6/9/2024. It is submitted by the learned counsel for the petitioner that the wife has filed assets and liabilities affidavit on her behalf in January 2025. In January 2025. This is on record. Having heard the learned counsel for the petitioner, this court is not inclined to issue notice to the other side, and the petition is disposed of. Observing that the recall and examination of the petitioner shall be confined to the purpose as indicated in paragraph 5 of the order dated 16/2/2026, that is with regard to the affidavit filed on 6/9/2024 by the petitioner husband. The learned conducting counsel for the petitioner shall have the liberty to bring to the notice of the court the aspect regarding the earlier examination and cross-examination of the petitioner husband, and regarding the said and regarding the earlier examination, the petitioner husband has already been discharged by the court. It would be in the interest of justice and fair play that the issues on which the petitioner was examined and cross-examined should not be further reopened upon recall of the witness, as the court itself has considered the aspect of filing of the affidavit on assets and liability dated 6/9/2024. It is submitted by the learned counsel for the petitioner that the petitioner stays in UK at his workplace, and he has to travel to attend the court on a date fixed by the court. The learned judge family court too is requested to accommodate his schedule to complete the cross-examination of the petitioner on recall by giving consecutive dates if required, so that the petitioner, after attending the court, can return to his workplace. For the said purpose, the application shall be made on behalf of the petitioner, and the judge family court too shall do well to consider and pass appropriate orders on the same. With the aforesaid observation, the petition stands disposed of. Yes, please.
Become 14.
Please, your lordship.
Yes, please.
Then, my lord, the challenge has been made to the order of the collector Baleswar by annexure 23, wherein a proceeding is pending under section 6A of the Essential Commodities Act.
Yes.
He has imposed fine on the petitioner, which is beyond the scope of section 6A. The fact of the case is the tanker of
the Essential Commodities Act.
Yes, ma'am. Only after the confiscation proceeding is found guilty, fine can be imposed. The lordship may see.
Better Act.
Yes.
Odisha rules are there, or?
Yes, ma'am. It is there. Essential
1955.
Again, 55.
Yes, please.
The lordship may see 6A.
6A, yes.
Where any essential commodity seized pursuant to order on section 3 so and so, President expedited, may order confiscation of the essential commodity seized, any package covering or acceptable in which such essential commodity is found, and any animal vessel so and so, provided that without prejudice to any action which may be taken under Act, no food grains on edible oil seeds in pursuant of an order so and so, your lordship may skip over.
Yes.
Then my lord, provided that in the case of animal, vehicle, vessel or other conveyance used for carriage of goods or passengers for hire, the other animals your lordship may skip over. But the collector on receiving report on seizure and inspection of any essential commodity on subsection 1 is opening the essential commodity subject to speedy and natural decay is so and so directed to be sold 1 and 2. Your lordship may skip. Provided that in case of food grains, the collector may, for equitable distribution and ability of fair price, order the same to be sold through fair price shops, your lordship may skip over. Then 3 is, where an essential commodity is sold as aforesaid, the sale proceeds, the EA is there. But the penalty is provided, your lordship may come to section 7.
Next, section 7.
Yes, madam. If any person contravenes any order made under section 3, he shall be punishable with a clause with reference to H or I of section 2 with imprisonment for a term which may extend to 1 year and shall liable to be fined. In the case of any order with imprisonment of term which shall not be less than 3 months but which may extend to so and so, provided that the court may for adequate and special reasons to be mentioned in the judgment impose a sentence of imprisonment for a term of 3 months. Any property in respect of the order has been contravened, any package covering unacceptable and so and so. So in fine can only be input after the conclusion.
So your contention is that 6A, 6B does not contemplate any fine.
Exactly, Milord.
Yes.
Correct.
And the order initiating the proceeding is?
Yeah, your lordship may see the initiating the proceeding. No, I'm just telling my two lines what is the fact. My tanker, the oil and petrol was going to the IOCL authorities from Baleswar to Keonjhar. The tank was apprehended by the police for the theft. 3 persons were involved and also they have included the driver of the tanker and helper. Then everything was seized, including some barrels and also a pickup van which was doing. Everything was seized. Then it was put up with the criminal case was going on. I have filed the documents against those 5 persons. The charge sheet has been submitted. Now on 8, your lordship has put the question. Your lordship may kindly see that particular date when 6A proceeding has been initiated at page 45.
Okay.
Page 45. Yes. There the case has been initiated. On the letter of the CSO on 6/11. In the report interest stated that on so and so Somnathpur depot opposite part number 3 was stealing, removing petrol from the opposite part 1 to 5 are the I am not there. From the so and so further in the report it stated that 200 liters of sky color.
4 is your driver, 5 is helper.
Yeah, no, yes. 4 is driver, yes.
1, 2, 3 are different persons.
They are different persons who are stealing. From whom seizure was made. I will show the seizure list also.
Okay.
Seizure was made from them. About 600 liters petrol, so and so. In the year, and may come to page 46. From the facts as narrated in the report, it is made clear that prima facie case under section 6A of the ECS is made. Start a case, ask RTO Baleswar to report the name and address of the owners of the boat who are to be implemented as 6 and 7. 6 is myself. 7 is the owner of the pickup van which was unloading from the tanker. 7. Then my lords, issue notice to the opposite parties. Now, next, my lord, annexure 15, I have filed a petition to release the vehicle. My vehicle from the
but this order does not I mean there is no direction to pay fine.
No. Subsequently, your lordship may see. Annexure 15, I have filed a petition to release the vehicle.
Release of the vehicle.
Yes, there, my lords, your lordship may kindly come to annexure 16. Order was passed on 24/11/2023 on the release of vehicle. Your lordship may kindly come to page 51.
Yes.
Last person, having considered the submission of Lord and APP and advocate for the OP number 6 material, the following orders is passed. The oil tanker bearing number released on interim basis in favor of subject to the compliance of the following conditions. OP number 6 Om Prakash Gupta, owner of the oil tanker bearing so and so, to file indemnity bond to the tune of rupees 2 lakhs.
You are not agreed.
No, I have filed.
You have furnished.
All have furnished.
Okay.
He should produce the vehicle as and when directed by the court. He shall not change the ownership. He shall not change the nature and engine so and so. He is to undertake the number of such type of vehicle he has owned. This is most important. The seized petrol and diesel in the tanker as well in the Ashok Leyland pickup van is to be returned to the IOCL Baleswar Depot Somnathpur Industrial Estate Somnathpur for fresh transaction which is to be acted upon by the IIC. The CSO Baleswar is to supervise the exercise of return of seized petrol and diesel to the oil tanker as well as seized Leyland pickup van so and so. The seized Leyland pickup van so and so be kept under seizure. I am not concerned. Then my lords, this has been complied. My lord may see the next annexure 17 is my indemnity bond. Then your lordship may see the FIR, your lordship may skip over. Then annexure 19 at page 74, the IOCL authorities has given me a mail that they have received the quantities of petrol and diesel from Supli product from return so and so. Your lordship may say 7.420 kiloliter. This is petrol and 3.910 kiloliter of diesel. Actually, it was 8 kiloliters and 4 kiloliters, some less because of the transaction. Then, my lord, the most important part, annexure 20, the order of the collector. In compliance to the order of this court in the instance case, advocate for the opposite part number 6 so and so filed an affidavit. The report of the IIC dated so and so, which speaks the IISO AS Baski has already been unloaded the seized petrol and diesel after executing from Jimanama to the DGM IOCL in presence of the CSO. The DGM IOCL has not returned the empty tanker till date. The IIC Badpa requested to pass necessary peruse the file, the affidavit indemnity board. The order is as follows. The seized vehicle number so and so, he is hereby released in favor of the opposite part number 6. Accordingly, extract of the order is sent to so and so. Now, my next grievance was annexure 21 to give me the price of the petrol and diesel which has already been received by the IOCL authorities. Annexure 21. When I filed a petition before them, they came back to me, the case is pending before the collector, we cannot pass any order. Therefore, I have filed a petition in annexure 22 before the collector to direct the IOCL authorities to pay the price of the petrol and diesel as per annexure 19. The order is annexure 23. My lord may see. What is the order? May be permitted, your lordship may see. Peruse the letter, gone through the record, appears that your lordship may skip over. On verification of records, compliance of the order in the instant case, the seized vehicle bearing number has been released in page 81. It starts. Third paragraph. On verification of record, it appears that in compliance of order, this court, the seized vehicle bearing number has been released in favor of the opposite part number 6, and seized petrol and crude oil was returned to IOCL, Odisha for fresh transaction. On further verification, appears that in compliance of order dated, the seized vehicle pickup van has also been released on interim basis. The OP number 6 submitted in written that the owner of the tanker bearing is a POL transporter of Somnathpur Depot, Baleswar. In the said tanker, so and so kiloliter was to going. The OP number 6 got information. I have also filed a FIR. Got information that some miscreants have drew some petrol and diesel from the said tanker by giving threat to the driver of the tanker, and due to timely arrival of the police, they could not remove. The police seized the vehicle. Further, the OP number 6 submitted that though the loaded diesel and vehicle tanker had been received by the IOCL authorities, they have not yet returned the cost of the so and so. The Lord Advocate for the OP number 7, you also may skip over. He said 7 EC Act was not made out from the records of the JMFC, which case is pending. On perusal of the case records, this is most important. Last paragraph. It appears that the Chief Depot Manager IOCL Somnathpur was issued summon to appear before this court of Collector Baleswar to adduce evidence on 30-10 and 23-5. Though the summon was properly served and returned to, they have not appeared yet.
In this is a matter still pending.
Yes, ma'am.
So why you have directed money to be paid?
Yes, ma'am.
You could have secured bank guarantee, or if you want,
yes,
you want anything, Mr. Mishra, you obtain instruction whether you furnish bank guarantee for that.
Yes, but your lordship,
I got your point. You are saying that they have directed deposit 4 lakh.
No, deposit. I was fine. That is your lordship may see the order. That is my main page 83. Your lordship may see. In view of the above,
83 only. I am there only.
It is clear that there is evil intention of opposite part number 6.
The fine is that Baleswar आज fine in shape of treasury challenge.
No, in lieu of confiscation.
Third, fourth.
Yes, confiscation has not been made.
Fourth line.
Yes, confiscation, and your lordship, the evil intention of OP number 6 and 7.
You want to secure the vehicle.
The vehicle is secure, but indemnity bond is given and everything secure.
You have granted, he has given also.
Yes.
But why money you are,
yes.
I don't.
And again, 4 lakhs fine to me as the fine for so and so.
Your lordship may kindly look at 6A.
Yes.
6A provided that without prejudice any action which may be taken under any other provision, no food can edible oil or pursuant to order made.
Mr. Mahanti.
Thereafter 8.
Mr. Mahanti, in a actually very complicated matter, don't submit without being sure of the facts. Because they have to tell you that what is the reason why they have done this.
That's instruction.
So you obtain instruction. But why you have directed for deposit of money, I could not understand also. I think you are also not confident. You cannot also understand. For that matter, nobody can understand. At this stage, why you have directed deposit of 4 lakhs in the treasury?
But that instruction.
My only submission that part soon, because he has directed to deposit within 3 months, which will expire on 5th. That's why that part I have.
That for interim order, you obtain instruction. I'll pass that interim
Yes,
order.
yes, let him take
But you obtain, because in fact, I don't know what they are doing.
Yes.
So some kind of security you furnish.
Yes.
You obtain instruction from your client. I understand your points.
Yes.
That he could not have. Because still the proceeding is pending.
Yes, yes, man.
He is not authorized under law.
But another important thing your lordship should have marked. In spite of the notice to the ISL authorities, they have not appeared because they have already received their oil. Your lordship, that part I am happy upon. Your lordship may see that order with due respect with page 82, last para. On perusal of the case.
And one thing I wanted to ask you regarding that, I didn't interrupt you. You are the owner of that particular
Tanker.
No, that fuel quantity which IOCL has received.
Yes.
Who is the owner?
Owner is the IOCL.
No, then why do you receive the money for that particular quantity?
No, because it used to be we have purchased it and you have supplied it.
So you are the owner.
Yes, that EA is there. That
bill is there.
Annexure 3 way bill is there. Annexure 3 is there.
You have purchased that oil.
Yes. And my lord, my total value was 11 lakh 92. They have received that. We have received a oil of 11 lakh 24. So that money, when I filed a petition before the collector that to release that money, he is telling you pay 4 lakhs fine.
I also do not understand.
Yes, my lord. That is my whole difficulty.
The petitioner had learned counsel for the petitioner. The opposite party hocchenti OP 1 and 2, Mr. P.K. Mahanti AC. 3 and 4. I'll dictate the order after recess because I have to attend something now.
Minus obligation.
Item 18 permitted to withdraw.
8.
181.
One is লেখি ঠিক দেবে সেটা আপনারা ঠিক আছে এটা রাখি দিও
Minus.
I'll continue after recess.
seeks a proviso manner. Provided further that the case of any animal, vehicle, vessel or other conveyance used for carriage of goods or passengers for hire, the owner of such animal, vehicle, vessel or other conveyance shall be given an option to pay in lieu of its confiscation a fine not exceeding the market value of the date of seizure of the essential commodity sought to be carried on by such animal.
I hope you marked that Mr. Mishra read that only.
No, he has not read my.
Yes.
He skipped
Yes,
that.
yes, yes.
That proviso and went to other proviso.
No. That is your impression. That is your impression that he did not. Upon a 6 or 2 provision.
Next,
Second provision.
second proviso, man.
ବହୁତ ଗୁଡେ provision ଅଛି.
No, second proviso, man. Reading is second proviso. My respectful submission is that also issue impose fine, my lord.
A, B, C पर second provision कौचत. That is regarding
option, my lord, not a.
That is regarding the vehicle and which is involved in the DA. My was transporting from which it was involved. Transport taken back.
And both the vehicle, my lord.
No, both the vehicles.
Both the vehicle have been.
ଆପଣଙ୍କର ଗାଡି ଚୋରି ଗଲା. ଆପଣଙ୍କ ଗାଡିରୁ ତେଲ ଚୋରି କଲେ ଆପଣଙ୍କର କଲିଗ. କାହାର କନଫିସ୍କେସନ ହବ?
ଦିଟା ଗାଡି ଚୋରି ହବ.
ମୁଁ ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଏମିତି ଶୁଣୁଛି. ସେ ଆପଣଙ୍କର ବିପଦ ବେଳେ ବନ୍ଧୁ ନୁହନ୍ତି. ଭୁଲ କୋର୍ଟରେ ବି ଭୁଲ ଗାଇଡ୍ କରୁଛନ୍ତି. ଆପଣଙ୍କ ଗାଡିରୁ ତେଲ ଚୋରି ହେଲା, ଆପଣ ଡିସ୍ପ୍ୟୁଟ କରୁନାହାନ୍ତି. କାହା ଗାଡିରେ ତେଲ ଥିଲା, କିଏ ନେଇ ଯାଉଥିଲା? ସିରିୟସ୍, ଡୋଣ୍ଟ ଷ୍ଟାର୍ଟ ଟକିଂ ଅଲୱେଜ. କାହା ଗାଡିରେ କାହା ତେଲ ଯାଉଥିଲା? ପଢିଛନ୍ତି ସେ କେସ୍? କେସଟା ପଢିଛନ୍ତି? କାହାର ତେଲ, କାହାର ଗାଡି?
It is the petitioner's vehicle, tanker, in which the oil was going, my lord. And the other. ଆଜ୍ଞା.
କାହାର ତେଲ ସେଟା? ସେ କ୍ୱେଶ୍ଚନ କିଏ ପଚାରିଥିଲା? ଆପଣ ଶୁଣୁନାହାନ୍ତି କୋର୍ଟରେ? This question was asked by whom? During today जो से कहले अधघंटे. Who asked this question? ताल छड़ देना मिस्टर साहू आर्ग्यू करिए. Both are PK, no difficulty. But गाड़ी कहाँ रहा अपन करो?
मतलब तो petitioners it is.
Petitioner भी चोरी करते ला. अपन के टाउन से
was not, but his vehicle was involved, man.
तेलोटा कहाँ गाड़ी रे थिला? petitioner को चोरी.
Petitioner गाड़ी.
चोरी तेलोटा कहाँ तेलो petitioner चोरी करते ला?
No, petitioner was not involved, man. His vehicle was involved, man.
तेलोटा
petitioner अगर टैंकर रे थला.
कहाँ तेलो सेटा?
Petitioners.
चोरी कहाँ रहला?
चोरी petitioner रहला.
अपन कहाँ को गोचन कॉन्फिस्केशन करिए?
No, it is in both the tanker and the pickup.
से प्रोविजन ना देखांतु. ଆପଣ ପିଟିସନର ତେଲ ଚୋରି କରୁଥିଲା ନେଇକି କୋଉଠି ଆପଣଙ୍କର ଅଛି କଲେକ୍ଟର ମହାଶୟ କହିଛନ୍ତି ଗୋଟେ ଆପଣ କହିବେ ଦେଖା.
The petitioner vehicle has been involved. That is the question.
अरे तेलटा କାହାର ପଚାରିଲେ ତ ଆପଣ ଉତ୍ତର ଦେଇ ପାରୁନାହାନ୍ତି.
ତେଲଟା ହଉଛି petitioner Indian Oil. From Indian Oil depot he was transporting the.
କାହା ତେଲ ସେଟା? ପଇସା କାହାକୁ ଦେଲେ ଆପଣ? ଆପଣ କାହାକୁ ପଇସା ଦେଇଛନ୍ତି?
Indian Oil. No. Petitioner gave money for the oil, my lord.
ତାହେଲେ ଇଣ୍ଡିଆନ ଅଏଲ ତେଲ କେମିତି ହେଲା? ଚୋରି କଲା, ଇଣ୍ଡିଆନ ଅଏଲ ଚୋରି କଲା?
No.
ଏମିତି କାଜୁଆଲ ହେଇକି କୋର୍ଟରେ କେବେ ଆର୍ଗୁମେଣ୍ଟ କରିବେନି. ଆଇ ୱିଲ୍ ରେକର୍ଡ.
No.
Yes, Mr. Mahanti, Mr. Sahu, I will record this submission. Be courageous to stand by your submission. I will record it. Yes, Mr. Mahanti, Mr. Sahu, I will record your submission.
No, your lordship. Order sheet.
Your lordship. Follow your lordship.
opinion 115 were.
नहीं आपण तो बहुत जानछंदी आपण जदी कहबे व्हाट एवर थिंग आई एम रिकॉर्डिंग नहीं मिस्टर महांती बहुत जानछंदी से कहउछंदी आई एम रिकॉर्डिंग बी करेजियस टू स्टैंड बाय योर वर्सन I always as a lawyer used to do that whatever I'll say I'll stand by that because that is my profession, that was my profession. I can take a stand and stand by that.
Only Lordship may kindly to see paragraph
be satisfied.
Gone through the records, and it appears that on 12/10/2023 at 3:30 p.m. at Somnathpur Depot Chak, opposite party number 1 to 5 were stealing, removing petrol, diesel from the oil tanker bearing registration number OD 22D 0571, utilizing Ashok Leyland pickup van bearing registration number OD 01F 7814. Further in the report,
से बड़ा गोटे जिनस पचारे आप कहि पारना एपर्यंत ऑयल टैंकर ऑयल कहार अशोक लेलैंड पिकअप टा कहार ऑयल टैंकर ऑयल कहार
Ashok Leyland pickup vehicle was of the other owner, Nasima Bibi Mail. That pickup van.
So she's the petitioner here.
No, she is not the petitioner.
You have partly understood. Now the oil tanker and oil was of whom?
Oil tanker is the Om Prakash Gupta.
Oil?
What is the oil he has paid, my lord? He has, on verification of that, the compliance of the court instead can seize the vehicle bearing OD 22 certain oil tank.
कौन करछुनी कोड एबा काई पढुछनी आपण जे पजो ऑयल टा कार ऑयल टैंकर टा कार
Oil टा होची IOCL palace.
I'll record that.
No, petitioner purchased the oil and was transporting it.
So Mahanti, you are making so many mistakes. I'm giving you an opportunity. If you are serious as a lawyer, as a contention, I'll record that.
I'll take it.
I'll record today. Today, I'll record it.
I'll take.
You take. I'll record your submissions first. Yes, Mr. Mishra, I'm recording his submission. Response it is submitted by Mr.
Instruction.
T.K. Mohanty, not an ASC.
And you only give instruction.
Submits that.
That's the manner record. Why it will be trouble?
No, they are serious.
No.
They are making a mockery of the proceeding as if the court doesn't understand.
I fully understand. I was also in that side.
Yes.
Protects
If you make a mock of the
that ain't not at all acceptable. What is not
the pretension as if the court doesn't understand and they are protecting the revenue should be on record. And luckily this is also recorded.
Lordship only notice and give instruction. That will be better. For this case, we'll take instruction.
No, he's serious. He's making the submission. It is submitted by the learned counsel for the petitioner, the additional standing counsel for the state, on being repeatedly asked who was the owner of the oil tanker that was carried the intended oil which was allegedly stolen. After much persuasion, he submits that the Ashok Leyland truck which was intending to carry the stolen oil belongs to one Nasima Bibi.
Yes.
No.
Yes. Ashok.
The pickup van was of
Pickup van. The pickup, Ashok Leyland pickup van.
Ashok Leyland pickup van.
Ashok Leyland pickup van. Should I be truck? Pickup van belongs to one Nasima Bibi, who is not the petitioner in this case. It is further submitted that the oil belonged to Indian Oil Corporation Limited, though it is specifically asserted by the petitioner that the petitioner had purchased the oil he being a dealer of,
No, I am not the dealer. I am only transporter.
he being a transporter,
Yes. The dealer has paid. It was
has been purchased by the dealer.
yes, the transporter.
Though it is specifically asserted that the dealer had purchased the oil from Indian Oil Corporation Limited, which was transported by the petitioner on the basis of letter dated 28/12/2022 for road transportation of bulk petroleum product for 3 years with effect from 16/12/2022 up to 15/12/2025. The oil was transported from IOCL Balasore,
Yes.
purchased by the dealer,
Yes.
that is Matasri Filling Station, KSK, at post Bhanda, district Keonjhar, by the transporter petitioner.
From it to it. ठीक है जी. लिखिए.
Yes, what else? कोटी confiscation proceeding कोर्ट डेट ऑर्डर आरंभ होला कोटी कंक्लूड होला. On being asked when by which order the confiscation proceeding was started and by which order it was concluded.
As a 14 you will not
Yes.
Peruse the 8/11/2020. Peruse the letter number applicate such and such.
So this is the initiation. It is submitted.
Yes.
It is submitted by the Lord Counsel for the additional standing counsel for the opposite party. So and so. The EC case number 02/2023 was initiated by order dated 8/11/2023. That is confiscation proceeding under section 6A of the Essential Commodities Act 1955 relating to IAPS case number 185 of 12/10/2023. Final order?
Final order. File is not final order. Annexer?
Annexer 23.
Annexer 23 is the final order.
Not final order, interim order.
Interim order. No.
Not final order.
Final order. Final order apno pachar.
The final order.
It is submitted that the final order in the said confiscation proceeding has not been passed. 5 बार पेज तक की ऑर्डर.
This was the order passed pursuant to Annexure 22 to the petition filed by the petitioner to release the amount kept to budget. I'm sorry, man.
Pardon, which order? 5 bar of change.
जोटा କହିଥିଲି ସେଇ order. କେତେଥର କହିବି ଗୋଟେ କଥା.
पांच बार 25 मिनट
ଯାହା ଅଛି ଆଜ୍ଞା 25 କୁ କଣ 26 କହିବି.
After compliance of the above order, further clause of action for release of the cost of returned petrol crude oil in favor of CC will be taken up. This is the part forward. This is the last order, madam. I told 24.
What is that order? Under which provision?
This is the order, an EC case number 220.
Can you direct the oil that was purchased by that dealer to be returned to the Indian Oil, which you have done?
Let us take instruction.
That is
Instruction of the.
what instruction? Have you answered that? What is that order passed on, which you have again and again, which date, which order? 5/12/2025. What is that order? Under which provision has been passed? On being asked, what is the nature of the order passed by the authority, order dated 5/12/2025? The allotted Additional Standing Counsel takes a long pause and does not answer the provision under which such order has been passed. He submits that 5/12/2025 is the last order. Yes, sir. How to justify payment of this money? And when I asked you that whose oil it is, why you were laughing?
No, I'm sorry.
I'm very sorry, Mr. Mohanty.
I'm sorry.
I marked both of you are talking and laughing.
No.
You should. Laughing is fine.
I'm sorry.
I'm extremely sorry. I'm extremely sorry, Mr. Mohanty. Don't take a ruse of saying sorry. Mr. Mohanty, you have to answer. It's not a matter of joke. Who is the dealer?
He is the transporter, my lord.
Who is the dealer? Whose oil it is? You are knowledgeable and prepared enough to laugh, but you should answer also that whose oil it is. Can you not find it out? Have you not seen? Then you are not listening to the order also. I have dictated already whose oil it is, who purchased who was transporting and who was stealing the oil. This is the last order. While passing the order dated 5/12/2025, the authority has not referred to any provision or the context where during pendency of the confiscation proceeding, he has directed deposit of rupees 4 lakh to the owner of the transporting vehicle that was transporting the oil purchased by the dealer as indicated above. It has been directed rupees 4 lakh the owner of the tanker bearing number OD 22D 0571, that is OP number 6, Om Prakash Gupta, is directed to deposit rupees 4 lakh into bracket, rupees 4 lakh bracket closed, then tinta dot. In the office of the CSO Balasore as fine in shape of treasury challan through proper receipt in lieu of confiscation within 3 months. After compliance of the above order, further course of action for release the cost of return petrol / crude oil in favor of the OP number 6 shall be taken up. Quote ends. Are being repeatedly asked and given sufficient time. The Learned Additional Standing Counsel has not shown the court any provision. And apparently, there is no such provision contained in the Essential Commodities Act, 1955, wherein during pendency of a proceeding under 6A, the oil purchased by the dealer from the seller Indian Oil Corporation can be directed to be returned to the Indian Oil Corporation. Further, there is no such provision. Stop, further, comma. There is no provision contained in the Essential Commodities Act 1955 that would authorize the authority to impose a fine of rupees 4 lakh on the transporter from whose vehicle the oil was stolen. However, the Learned Additional Standing Counsel relies on co-provision section 6A.
Section 6A, second provision.
Next page.
In page 9.
जेहेतु बहुत गुड़े प्रोविजन 5टा 6टा प्रोविजन अच्छी आप गोटे टिक मार्क करके दियो पेंसिल टिक मार्क कर दियो सेटा एटा नॉर्मल पेंसिल
Here
तो देखा तो मिस्टर गोयल अपन सेटा भी देखा
ए मोबाइल अछि मच
ठीक कोटा प्रोविजन पॉइंट करछ दिले
आज्ञा सेटा मु
ठीक अछि कत दिन
सर
कौन लिखले However, the Learned AC relies on section 6 capital A dash English 1. Section 6A English 1 second provision. So kindly, Mr. Mohanty, kindly take that section.
My lord, read my lord.
Yeah, 6A.
6.
Oh.
Confiscation of essential commodity.
Yeah, bit slowly we have to go there. Yes. Where any essential.
But essential commodity is seized in pursuance of any order made
Not any order, an order.
of an order made under section 3 in relation thereto, a report of such seizure shall without unreasonably delay be made to the collector of the district or the presidency town in which such essential commodity is seized, and whether or not a prosecution is instituted for the contravention of such order, the collector may, if he thinks fit, if expedient so to do, direct the essential commodity so seized to be produced for inspection before him. And if he is satisfied.
So now, Mr. Mohanty, I hope you understand.
Ma'am.
So what was seized?
Seized is the oil and the vehicle.
Sure and confident, I'll record that.
Vehicle was, it was later released.
That everyone, but being a lawyer or being a student of law, I am. So what was the essential commodity and what was seized? I'll record that transporter, what was carried by the transporter was seized by you, because I have to reflect that. Now read section 3. I hope you understand what I am telling you. If you know, if you are unable to follow, I can tell you again what I am asking you.
Section 3, power to control production.
Mr. Mohanty, maybe I think I have not been able, you are not following me. I have to tell you, I'll represent it in a different way. Same thing, same facts, I'll just represent you in a different way. What are the facts involved here? There is a depot. Correct. Followed. Depot of
oil.
Indian oil. Where it is? Balasore. Then there is a dealer. Dealer has purchased oil. There is a transport contractor. Engaged by whom?
Engaged by the dealer.
No, that's one. Transport contractor is by the IOCL.
Yes.
Who is the purchaser?
Purchaser is the dealer.
Purchaser is the dealer. Seller is the
IOCL.
IOCL.
Yes.
Transporter engaged by IOCL.
Man.
So, whether you can seize that property. Purchaser has purchased. And it is in fact, there is no dispute or doubt even like that. That's absolutely, there is nothing. So then what has happened? 3 persons come with a Ashok Leyland pickup with barrel. They intercept the truck or whatever. Or they have a kind of what you call their hand in glove or whatever. To that Ashok Leyland truck, the oil that was carried in the tanker of IOCL purchased by the dealer, by the transporter as per the contract, is stolen. So what is the stolen good then?
Oil
Where?
from the tanker,
Not from where? Where?
very from the highway.
Where means which was the vehicle carrying the stolen property?
That pickup van.
You have got it. It took some time, but you have understood it. Now, where you will operate 3, where it will operate? For the pickup van or for the tanker?
So pickup van.
Pickup van. But anyway, at least I could make some headway. I told you that it is really a very complicated in the sense, though it is very simple otherwise. I asked you that you have purchased oil from and you are carrying it. Carrier is somebody else and it is stolen on the way. Now, what you have done, the tanker you have seized and maybe the tanker, I don't know whether, what is the, because ultimate analysis I cannot say. And you have taken away that oil also. সেটা কোট করে দেবে है ना, which is reproduced here. তাহলে সেকশন দিট জায়গাটা পুরোটা করে দেন তো 6A1 up to blue tick কর দেব। And that is how you are above, this profession is above these things. A collector at a person at the level of administrator level collector, what he has done? He has seized the authorized oil that was transported and there is absolutely no allegation also. Direct or indirect, nothing. There is absolutely no allegation against that. The oil that was carried in the tanker to Kendujar, that is stolen property. There is absolutely no allegation. You can reread at leisure also, no difficulty. At times the basic fundamentals creates this unnecessary litigation. What was the reason for taking away that oil which was carried in the tanker? And in fact, CSO has not written that. CSO has not, read the report of the CSO. IOCL has not written that also. Nothing is there. There is a possibility, suppose. Like what? Hanipa Bibi or what is that? Whoever, somebody else, he will still utilize your tanker or that tanker and taking away the control commodity. That's possibility. But that is not the case here. কোট করে দেলে পারা তারপরে লিখিবে মিশ্রঙ্কর সবমিশন গুড়াক সেটা আরম্ভରୁ ରହିବ। Had learned counsel for the petitioner. The petitioner is a transporter of essential commodity having entered into a contract with the opposite party number 3 and 4, Indian Oil Corporation Authority, opposite party number 3 and 4, authority of opposite sentence out there. Mr. Mishra will take your seat. Mr. Mahanti, you also. You have done your part. Now I have to dictate. Well, having entered a contract with IOCL, Indian Oil Corporation Limited, for transportation of bulk petroleum product for 3 years with effect from 16/12/2022 up to 15/12/2025. The said transportation contract for transportation of bulk petroleum products copy of the said transportation contract has been annexed to the writ petition marked as Annexure 2. Pursuant to the said contract, the petitioner, transporter was directed / entrusted to transport 8 kiloliters of petrol and 4 kiloliters of diesel by the IOCL from Somnathpur Depot at Balasore to Matasri filling station. Para 6 to देखिए spelling good. Matasri filling station from at / post Honda BHNDA district Kendujhar by the oil tanker number OD22 capital D 0571. The oil has been purchased by the invoice dated 11 October 2023, Mr. Mamisra. Page 20, date
11 ଅକ୍ଟୋବର 23 ରେ ହେଉଥିଲା 12 ଅକ୍ଟୋବରରେ ଟ୍ରାନ୍ସପୋର୍ଟେସନ ହେଲା ଆଉ
PC.
ଆଜ୍ଞା ଆଜ୍ଞା 23 ରେ ଆଜ୍ଞା 23
11 October 2023, indicating the name of the supplier and the name of the consignee. The said copy of the said invoice has been annexed to the writ application marked as Annexure 3. ମୁଁ ଡେଟଟା ଠିକ ପଢିଲି ତ ନହେଲେ ଆଗରେ କନଫ୍ୟୁଜ ହେଇକି
ନାଇଁ 11 ଅକ୍ଟୋବର 23 ଠିକ ଅଛି
Yes, kindly take your seat. If I require, I'll ask you.
Yes, 11 ଅକ୍ଟୋବର 23
Following the said invoice, oil was transported. Oil was being transported on the way to the destination as it is alleged. The oil was stolen by utilizing
Lord's Mercy, page 23, the FIR last paragraph, first page, last 4 lines.
32 रे जो सीजर लिस्ट अच्छी से देखिए
आज्ञा
32 सीजर लिस्ट
आज्ञा 32 सीजर लिस्ट अच्छी सेटा आज्ञा सेटा is very important also because no your Lord's Mercy page yes page 28 my Lord Mercy seizure list just a minute page 28 is the seizure list this all this has been seized from that person the first seizure your Lord's Mercy 12/10/2023 से बात तय रात्रि रे
The oil was stolen by utilizing a Ashok Leyland pickup van carrying plastic barrels.
Again.
The seizure list produced before the lauded JMFC Balasore.
All these articles were seized from one of the person from the three persons.
Marked as exhibit.
Which is the
Dated 12/10/2023.
Yes. And
It indicates the article seized as following. Reproduced contents. 1, 2, 3, 4, 5. अच्छी पेज 28 रे अच्छी.
Again.
Para.
And there is also another seizure list pursuant to my FIR that is at page 32. This is the oil tanker was seized and
After the incidents of theft, yes, the petitioner, owner of the petitioner, transporter, owner of the vehicle.
I have given the
carrying the oil.
My FIR is at page 30.
Also lodged an FIR that has copy of which has been marked to the writ application as annexer 5.
5 series minus.
FIR dated 12/10/2023. FIR dated 12/10/2023. Pursuant to the said FIR, the seizure list has been enclosed, marked as annexer 6.
Yeah.
Which indicates the following articles to have been seized. 1 to 6, page 32. Para. It is further submitted that the opposite party, number 1, collector Balasore passed order. केबे फेरिया पे अपन
order कले
जो विक्रेता को देवा ପାଇଁ कहले
आगे सेटा होचे आगे लॉर्डशिप में काइंडली सी ऑर्डर डेटेड 24/11/2023 at page 50.
It is submitted that the order dated 24/11/2023.
Relevant portion page 51.
In his case number 02 of 2023. The collector and district magistrate being the authority under the EC Act passed following orders. 51
having considered the submissions, your last
having considered page 51, having considered the submissions of Learned APP to Neki up to
next page also to return to IOCL.
But should I say clear lekhileni collector?
नहीं.
The court है फेरा हो बोली.
तो सबू लेखिले.
तो entire फेरी देले.
आया. The seized petrol and diesel in the tanker, as well as Ashok Leyland pick mobile is to be returned to IOCL.
So that is contained in that. अच्छा सेक्रेटरी थिला आपनकर बैरल रे थिला.
बैरल रे थिला. मोर ओरिजिनल जो तेल थिला सेथरे बैरल रे थिला जो गुडा को चोरी हिच. से दीटा जाको पठेई दे. दीटा गला.
May I say something, Lord? I am confused because of the fact. May I sort your lordship's
No, you make. You make your submission instead of.
Because I have not gone through the entire record. That is difficult, but the 6A provision what dealing with both essential commodity as well as the vessel or the vehicle.
No, what is your submission you say?
My submission is this order is passed under section 6A with regard to the vehicle. And the court
who has said that this order has not been passed?
Yes, that is that.
No, why you are stating the obvious? So that is in
the court has held. Kindly appreciate, Miller. One thing, Miller. What I got from this order.
Be kind to be clear in your submission. So
yes,
this is one time. You have been asked something that who has said that it is not regarding the vehicle.
This is a finding is given at the last para. Kindly, Lordship may see, Miller. In view of the above discussion, I am going to the last paragraph. It is clear that there is a evil intention of the OP number 6 and 7, the owner of both the vehicles. Accordingly, the owner of the tanker bearing number so and so, that is the OP number 6, Om Prakash Gupta, is directed to deposit 4 lakhs, and the owner of the pickup van number so and so.
Which provision, Mister? You are so kind towards us. So also tell that under which provision that is
6A, Miller. 6A.
Sir, then you have not heard Mr. Mahanti. It has been 6A
is
6A has been entirely quoted. That is a submission.
6A is there is a provided clause giving option.
So 5/12/2025 order is under which provision?
6A, my lord.
Where is that? What is that mentioned in that order?
The 6A is not legal. The fine is contemplated under 6A.
Sir,
My
sir,
submission.
you are not only kind, you are thoroughly confused. You are so confused that nobody is asking you. Apart from being kind, you should not be confused.
Yes.
Who is saying that you cannot impose fine? But where is that provision that where you have concluded the passed the order of confiscation? Where you have passed that order? Kindly, so you are definitely kind. So you are reading which paragraph?
Before
Which
passing
page?
final.
Mr. Sahoo, kindly listen. Which page you are reading?
I am reading 6A.
अरे आपण ऑर्डर को पेज रे पढुचंती 6
The operative portion.
को पेज
83.
केते समय लागु छै आपण रेस्पोंड करिया पे
Sorry.
सॉरी तो एते क्विकली कहउचंती से रेस्पोंड करंतु टिके 83 टा आपण जोडा पढुचंती फर्स्ट लाइन को जानतु 80 रे पेज 80 हाफ बेक्ड हेले ए प्रॉब्लम हो पांच बार अंता आपण पढी ना दैट्स द प्रॉब्लम
Sir, before.
Right, kindly read 5/12/2025.
My lord. Here is the letter number so and so dated 6/11/23 of the CCSO Baleshwar along with the report of IO so and so bearing DR number so and so praying to initiate a confiscation proceeding under section.
So that's the first date.
This is the first date.
So first date you have decided the confiscation proceeding.
No, I am yes, your lordship is correct. This is if
no, lordship cannot be. I am not competing with you or the collector. I am asking you a question. So when did you initiate the confiscation proceeding? That is another order. So this you have passed the order. You have not. Then you kindly read.
Then yes, gone through the record and it appears that on so and so date at Somnathpur depot, opposite part number 1 to 5 were stealing, removing petrol, diesel from the oil tanker bearing number so and so, utilizing Ashok Leland pickup van bearing number so and so. Further in the report, it is stated that three numbers of 200 liter capacity of sky color plastic barrel containing about 600 liters of petrol. Three numbers 200 liter.
Kindly read. You are Mr. Sahoo, kindly read page 82, last paragraph.
Yes, my lord. Last paragraph. On perusal of the case record, it appears that the chief depot manager IOCL Somnathpur Baleshwar was issued someone to appear before this court, court of collector Baleshwar for adducing evidence on that so and so date. Though the summons were properly served and returned to this court by letter number so and so of Tahsildar so and so, but the chief depot manager remained absent.
So so what is the evidence? How you have proceeded on the confiscation?
My respectful submission.
So the collector himself is the prosecutor or is the adjudicator?
May submit, please.
Sir, kindly, apart from submitting, be kind enough to understand. So you must understand what you are submitting. So you have not concluded the confiscation proceeding.
Before concluding the confiscation proceeding, my lord, there is a provision.
So what is the evidence on that you?
Provided clause is there.
Sir, you are not reading. That's the problem. You are overconfident.
No. I am
please answer.
No.
Please, I'm not. This is not again. I'm not. This is not a matter of fun.
No, not matter of.
If you have initiated and concluded a confiscation proceeding, please place that on place before. So Mr. Mohanty did his best also.
Again, I will take you to the.
Please don't take you anywhere. You state in two lines. By which order you have started the confiscation proceeding and by which order you have passed final orders.
My respectful submission to your lordship's court.
No, don't be respectful. State away, give the date.
Yes, I am submitting, my lord. Before finally passing a final order under section 6A, the provision says the option has to be given to the owner of the vehicle.
Sir, you are not invited to take a class. You know so many things. Please answer. And which order you have initiated the collector as you are a representing collector. You are so kind. So please come to the court also tell that by which order the collector has initiated the confiscation proceeding and what is the final order in the confiscation proceeding.
Now, my respectful submission is this order deals with the confiscation proceeding under section 6A, and before proceeding further, the collector has on the provided clause has given an option to the owner of the vehicle to deposit the market price. If it is a option, my lord, in the form of.
Sir, by which order for the 15th time by which order you have initiated the confiscation
But
proceeding.
this order, my lord, 5/12/25.
5/12 you have initiated.
Yes, my lord.
The Lord Additional Standing Counsel, Mr. P.K. Sahoo, supplements the arguments of Mr. P.K. Mohanty, Lord Additional Standing Counsel, to submit that. Six A proviso deals with the vehicle carrying the essential commodity, which is actually a reiteration of the submissions of Mr. Mohanty that has been recorded above. On being repeatedly asked for 6 times or more that by which order the confiscation proceeding was initiated and by which order the final order was passed by the collector in the confiscation proceeding, the Lord Additional Standing Counsel, Mr. Sahoo, has no answer, apart from saying that on 5/12/2025, the confiscation proceeding was initiated. Perusal of the said order dated 5/12/2025 has an interesting aspect regarding the witness and the evidence as recorded by the collector. And it reads thus, page 82, quote, on perusal of the case record, it appears that the chief depot manager so and so up to was remained absent. Para. Assuming the submissions, though the submissions made by Mr. Sahoo on a DSC is factually incorrect, as the authority has not recorded that how he has arrived at a conclusion or how he has initiated the confiscation proceeding or evaluated the evidence. Assuming that the said order 5/12/2025 can be treated, assuming for the sake of argument, the said order is the final order passed in the confiscation proceeding. At running page 83, internal page 4 of the order, the following has been observed by the collector. In view of the above discussion, it is clear that there is evil intention to neki shall be taken up. Though it is made out, though the said order itself does not indicate if effort has been made by the learned counsel, Mr. Sahoo, appearing for the state that the said order is an order of confiscation. MFSA, the counsel for the state has not been able to repel the contention that the confiscation proceeding, when initiated and to what extent it has proceeded and when the final order has been passed, is not indicated in the order dated 5/12/2023. Significantly, the authority has noted the absence of the primary witness, that is Chief Depot Manager IOCL, Somnathpur. The order also does not refer to any other witness or material on record or any evidence. regarding the confiscation of the vehicle owned by the petitioner, that is OD 22D 0571 oil tanker that was utilized pursuant to the agreement between the IOCL and the petitioner transporter. Issue notice along with this order. P.K. Mohanty, Lord AC, upon advance copy served appears and waives notice on behalf of the opposite party number 1 and 2. Notice to the opposite party 3 and 4 by speed post with registration and proof of delivery. Requisites for issuance of notice to the OP number 3 and 4 be filed within 3 working days.
5 working.
Within 5 working days. Fixing returnable date to fixing returnable date to 26/3/2026. List after Orissa from OP number 3 and 4 liberty to mention. IA 3837 of 2026 flag A. Hard Learned Counsel for the petitioner. The petitioner has the petitioner, the Learned Counsel for the petitioner, as well as both the Learned Additional Standing Counsels were heard extensively regarding scope of Section 6A of the Essential Commodities Act. The Learned Counsel for the petitioner, as well as the Learned Additional Standing Counsel, as well as both the Learned Additional Standing Counsel reiterate their submissions as noted above. Issue notice as above. The Learned AAC upon advance copy served appears and waives notice on behalf of the opposite parties 1 and 2. Notice to OP number 3 and 4 shall be issued along with the writ application, accept one set of process fee as well as postal requisites. In the interim, it is directed that operation of the interim of the order dated 5/12/2025 into bracket annex to the writ application marked as Annex 23 regarding deposit of rupees 4 lakh by the petitioner transporter shall remain stay in disposal of the until further orders.
Obliged.
List in the week commencing, returnable date in the week commencing PDC 3/2026. Liberty to mention. Yes, next.
Urgent copy. Obliged.
Urgent copy as per rules. But take some time.
Yes, yes. I'll find it.
In fact, the sharing has been, it can be disposed of easily.
Yes, that is case.
Wherever it goes, maybe
No,
this quota.
because the money is lying with the ISO authorities, I have to make them parties. Otherwise, it can be disposed. They have to come and say.
No, but you perhaps, I don't know why you have not raised that. You did not argue that point seriously, that how the oil can be sold again to IOCL.
Because
they are no holy cow.
No, they have given.
They have sold the property.
Yes, and they have
whether the property was stolen from you and you sold, that's another thing. But the rest of the property they have sold it to IOCL.
Yes, friends. They have given to IOCL. They have given.
And why is it the Matasri has not been made a party?
No, in the EC case.
No, while directing also, it is Matasri's property.
Yes, Matasri should have been there.
I don't know what is happening.
Yes, by the collector hypothesis should have been met in the.
At least Bhattacharya should be asked that you the oil you have purchased, I'm sending it back to IOCL.
Yes, and whether you have received it or not.
Yes, next.
Transfer item 6.
Sixth action pass over. Not appears for the petitioner, though the matter is called twice over. Once when it reached, and again after resumption of the proceeding of the court after recess, none appears for the petitioner. Acha, do the matter. To grant further opportunity, list in the week commencing. 16/3, 2026. Yes, next.
Transfer item 9.
6 টা স্যার মোচ 6 না
6 na 3 is that good.
Oh, 6. I thought that no one is appearing, so. Mr.
3 সুবিলা স্যার
Acha, Mr. S.K. Sodangi, senior advocate, along with Mr. Gyananandan Naik for the petitioner. It is 6 order. No appears now.
ଆଜି ତ ଅଧା ଟାଇମ ଆଉ ନାହିଁ ବୋଧେ ଯଦି ରହିବ ବି ଗୁରୁବାର ଦିନ ରହିଲେ ହବ
ନାଇଁ ଯଦି ଏଇଟା ଆର୍ଗ୍ୟୁ କରିପାରିବେ
ନାଇଁ ଗୋଟେ ଟାଇମ ଲାଗିବ ଟିକେ
ଗୋଟେ ପୋଷ୍ଟିଂ କରିଦିଅନ୍ତୁ ଗୋଟେ ଡେଟ୍
ଗୁରୁବାର ସାର୍ ଟିକେ କନଭିନିଏଣ୍ଟ କାହିଁକି ମତେ ହ୍ୟାଙ୍ଗିଂ ଅନ୍ ବି ଅର ଶୁକ୍ରବାର
ୱିକ୍ କମେନ୍ସିଂ 5 ୱିକ୍ କମେନ୍ସିଂ 5 ରଖିବେ 5, 6, 7 ଯୋଉ ଦିନ ଆସିବ ଶନିବାର ସାର୍ ମନା କରୁଛନ୍ତି ହେଲା ରଖିବେନି 7 ରେ ଆସିବନି ଏହା କହୁଛନ୍ତି ତ
କହୁଥିଲେ ନାଇଁ ଯାହା ସୁବିଧା
ଠିକ ଅଛି
ଥାଉ
କରିବେ ନା ତାଙ୍କ କନଭିନିଏନ୍ସ ଦେଖିଲେ ହବ
କୋର୍ଟର ସବୁବେଳେ କନଭିନିଏନ୍ସ
ଡେଟ୍ ସେ ଦେଖୁଛନ୍ତି ଆଉ
Item number 9.
9.
2 weeks after Bishop Puja, within another court. 2 weeks time.
the ଆପଣଙ୍କ ନାଁ ସାର୍
PK Raut, sir.
ଆପଣ ପାୱାର ଅଛି So PK out for the petitioner, opposite party blank. The matter is called twice over. It is submitted by the twice over, once when it reached, and again after resumption of the proceeding of the court after those recess. Adjournment is sought for in absence by Mr. Raut, in absence of his leader. List in the week commencing, sir.
2 weeks after.
16 na 23 ke becha 16 we come to 16 yes next please
15
এটা পাস ওভার না সিরিয়াল লেকচার
na serial.
তা কহিবে না তাহলে যে শুনছেন সে কনফিউজ হয়ে যাবেনি তাহলে বেশি রিজেক্টিভ সে আউরি কনফিউজ হয়ে যাবে
And in this case, instruction was sought for from the Journal of Bengali. He has stated that the cause of action still survival. And the order was as per order dated 16/7/2025, my lord.
The affidavit
cause of action.
Mr. Mahanti, you ask them to file an affidavit because they take it easy when they take there is an order dated go to 16/7 order.
My lord.
Can you find that 16/7 or look here in the
Here
you have
Yes.
kindly go through that.
Last
Yes.
7 para. In the meantime, learned counsel for the state is directed to ascertain from the office of the special land acquisition, rehabilitation and resettlement officer, Bengali irrigation project appellant, as to whether any cause of action still survives to pursue this appeal. My lord, in reply to that, they have stated that.
What is that? Se to kahibe je achhi boli, but kon ta achhi?
In the letter, they have stated that.
Yes.
Agree.
I mean, have they indicated anything?
No, they have not indicated. They have stated that the enhancement of land acquisition compensation passed by the learned court of the civil judge, senior division Kamakhya Nagar, from 35,000 to 62,500 per acre has been challenged along with legal and valid grounds. Therefore, the cause of action still survive. That they have stated in the instruction.
And other aspect is that since that is passed by coordinate bench, it is simply because the bench has changed that should not be, relegated to the back burner. So that is the other concern also. It shouldn't appear that as if since now it is a different bench, so earlier order I will ignore. So that is other purpose. Okay, you give that copy. Extra copy achi?
No,
Xerox kar diyo. Quality they developed is some in rest. The allowed additional standing appellate. Mr. P.K. Mohanty or appellate. Opposite party blank. The allowed additional standing council refers to the order dated 16/7/2025 passed by the coordinate bench, wherein at paragraph 7 the following has been indicated. Was indicated. The following was direct. The following was observed. Para 7 को quote कर दियो. Stop para. It is submitted that pursuant to the said order, instructions were sought for from the appellant, Special Land Acquisition Officer, Ringal Irrigation Project, Baghua Board, Talcher, by letter from the Office of the Advocate General. Para. In response thereto, it has been indicated that it has been indicated in the letter dated 22/48.02.2026 from the Zone Officer, Ringal Irrigation Project, that the enhancement of compensation directed by the London Referral Court, that is London Civil Judge Senior Division Kamakhya Nagar, from rupees 35,000 to rupees 62,500 per acre is under challenge based on valid and legal grounds. A copy of the said letter dated so and so is kept on record. But a memo से तो दे दो, just अपन दे दो. Accordingly, in view of the clear instructions from the appellants to the London Additional Standing Council, notice के भी issue है नहीं.
Notice was issued, madam.
केबे कोड order था?
Limitation. Issue notice, madam. 22 February 2008, madam.
No one is appearing.
Nobody is appearing. Delay has not been confirmed, my lord, in this case. Though they are substituted, they are not appeared.
पण आउ थोड़े नोटिस नहीं जाते नॉले एमती बारंबार आसे कि to just be simply getting adjourned. On perusal of the order sheet of the appeal, it is apparent that by order dated order number 3 dated 22/2/2008, notices were issued to the opposite parties on the question of delay in MC number miscase. So MC tila M.C MC number. So 164 of 2006. Stop. Also by order number 4 dated 22/2/2008. Notices were issued in the appeal. ଗୋଟେ କାଗଜ ଦେଲେ ମେମୋ ଲେଖିଦେବେ କାଗଜ ଗୋଟେ ଦେଇ ସଫିସିଏଣ୍ଟ ହେଲା ବୋଲି ଜାଣିଛନ୍ତି କି ଆଉ ଥରେ 10 ରେ କଣ ନୋଟିସ ଇସ୍ୟୁ ହେଲା can you see ଆପଣ ସେଥିରେ ଅର୍ଡର ସିଟ୍ ଏଇଥିରେ ଦେଖନ୍ତୁ
ଏଇଥିରେ କେମିତି ଦେଖାଯାଏ
ଅର୍ଡରଟା କ୍ଲିକ୍ କରିଦିଅନ୍ତୁ order number 5
ଏଇଗୁଟା
3 4 ରେ ବି ନୋଟିସ ଇସ୍ୟୁ ହେଲା 4 5 ରେ ବି ଆଉ ଥରେ ନୋଟିସ ଇସ୍ୟୁ ହେଲା
ଆଇଟମ କେତେ ଆଇଟମ 15 yes what's it order number
हैंड रिटन ऑर्डरটা ଦେଖିଲେ फर्स्ट पेज को पढाନ୍ତୁ ऑर्डर शीट तापर हैंड रिटन आरंभ होला ऑर्डर नंबर 3 देखंतु
हां
notice in the limitation
आज्ञा
4 notice in the appeal
आज्ञा
तापर आपण डाण पटे रिक्विजिट्स फाइल हेची देखिबे नोट शीट अछि
आज्ञा
अगेन देखंतु आउ थरे
रिक्विजिट्स
ऑर्डर नंबर 5 गोटे पेज पर आसीबो
टाइप कॉपी यस
अगेन अदर नोटिस इश्यू होला
हाई इश्यू नोटिस रिक्विजिट्स स्टे 50% digital due stay was granted.
किंतु प्रॉब्लम कोन होची कहले माने I don't know.
Stay was also granted.
No, why two notices have been issued?
Yes.
By two
at the stage of
judges.
Yeah, yes. Execution statement. The execution statement.
Notice issue ने stay होता भी क्यों?
हाँ.
बर्तन मुगन थर्ड टाइम नोटिस इशू करी.
नोटिस सफिशिएंसी टा देखियो.
सफिशिएंट मु खोजी बाहर करियो ता पर आपण तो सेटा को मते असिस्ट करनांती मु मते
नोट शीट
बट आपण को दिन को नोटिस हला के कोथरे रिक्विजिट दिया हला केते थर नोटिस हेची आपण ऑर्डर शीट देखिले आपण ब्रीफ रे मिस्टर साहू मिस्टर महांती आपण देखिथिबे ना आरंभ देखंतु
नोटिस 2014 रे रिटर्न हेची नोटिस इन लिमिटेशन मैटर इश्यूड टू R1 1 to 5
व्हाट अबाउट अपील टा देखंतु तने
ऑनसर्व नोटिस रिटर्न फ्रॉम R1 3 and 5 1 and 3 and 5 with common postal remark death return to sender thereafter
1 ता माने 135 सब्स्टिट्यूट करिवे
आगे सेटा ऑर्डर स्पेस फॉर सब्स्टिट्यूशन 1 3 and 5 यस
आपनकर केबे आपण ऑर्डर शीट केबे नोटिस आपण नै चंदी तो मानती
on 28/1/2010 माइलो
ता पूर्व जोटा ऑर्डर हेची जस्टिस पंडांकर 8 मसिया रे किछ नोटिस हेनी
हां यस on 22/2/2008 माइलो इशू नोटिस फॉर लिमिटेशन ओनली
नहीं अच्छा so though the court has directed for limitation and appeal both आपण खाली लिमिटेशन
also appeal
8 रे थारे 10 रे थारे
हां 8 थारे 10 रे थारे
ऑर्डर नंबर 9 टिके हाथ लेखा अछि एते स्टेप गुड अछि सर 10/12/2024 ऑफिस नोट ऑर्डर नंबर 9 हाथ
ऑर्डर नंबर 8 रे होची जे 24 बट प्रॉब्लम होची कोन कहले बेले बेले sitting here we are unable to know and we are directing sufficient but actually sufficient है कि नहीं जाना नहीं
it's a लेखा है जी ता परटा
सेटा that becomes fatal for in a land acquisition
steps for substitution are 3 not taken एटा ऑर्डर नंबर 9 रे ऑफिस नोट
2 and 4 के sufficient हला देखिले
2 and 4
I'll take a break for 10 minutes and come back.
Yes, yes.
But by that time you flash
I'm searching. Substitute that is the observation. So far as 1A, ये सर मैं देखूँ जी अपनों को towards last 1A 1B 5A 5A 5C 2 and 4 रे
No, I understand. Please look at order number 8.
non appear for 2 and 4 लिखा है सर.
So order number 8.
Order number 8.
11/24. Para 2. So far as notice to the respondent, you got it?
Para 2. Again.
So far as notice to respondent number 2 and 4 in view of the office note, the same is deemed to be sufficient. So office note ta ko date रे actually सेटा जଣା पड़ुनी.
ଆପଣ ଯଦି ପଛ ଆଡୁ ସାର୍ ଯିବେ ଜଣା ପଡି ଯାଉଛି କୋଉଠି କୋଉଠି ସବୁ ସବଷ୍ଟିଚ୍ୟୁଟ ହେଇଛନ୍ତି ଟୁୱାର୍ଡସ୍ ଲାଷ୍ଟ ଆଡକୁ ସାର୍
2 and 4 ରେ କୋଉ office note sufficient ହେଲା?
ऑर्डर नंबर 11 को सर आसंतु सेउटु सर आगु जले जଣା पड़ी जाଉଛି
ऑफिस नोट कोटा
ऑर्डर नंबर 11 पेज आपनकर 24 पेज 24
पर जदी 8 रे 2 and 4 सफिशिएंट ताल 11 देखिया दरकार ही नहीं तो ऑलरेडी सफिशिएंट बट को ऑफिस नोट रे सेटा देखिया को मु चाहूची
सर पेज 24 को सर आसन सेउटु सर गडे गेल जଣା पड़ी जाଉଛି पेज 24 ऑर्डर 11 एठी आईए फाइल लेची
डेटेड ऑर्डर नंबर 11 24/6/25
आगे आगे हां सेठी फाइल हला तीनटा आई फाइल हला फॉर R1 सेकंड रे हला इटा होची 8 फ्लावर सफिस
नहीं आपण तो 1 3 and 5 कथा कहउछथि
हां हां
मु 2 and 4 कथा पचारुछि
2 and 4 नॉट एट अपीयर्ड लिखाई जे अपीयर्ड लिखाई जे नोटिस मते सफिशिएंट सर हेइथिबो
सेटा पचारुछि
हां नॉट एट अपीयर्ड में सफिशिएंट कोठी लिखा होछि तबो
बार तो 14 दिखाते
बार 14 नोटिस इन लिमिटेशन नोटिस आर एडी रिटर्न फ्रॉम 2 and 4 आफ्टर साइंड बाय स्मिता रानी होता बट रिलेशन नॉट स्टेटेड आंसर नोटिस रिटर्न फ्रॉम 2 and 4 yes
so 2 and 4 is also not sufficient
सेठी भी सफिशिएंट लागुनी रिलेशन नॉट स्टेटेड
अब तो नहीं जाने नोटिस
सब आउटर प्रेस नहीं जाओ
कौन लिख ले yes correct yes stop करी लेखो stop also 22/2/2008 appeal para somehow another coordinate bench तो issued लिख लेनी थी issued by a coordinate bench होते प्रथमटा तापर somehow another coordinate bench issued notice again by order number 5 dated 28/1/2010 and order number 6 28/1/2010 for condonation of delay in which case number 164 of 2004 and which case number 1 of 2010 seeking stay of operation of the impugned award. The office note dated 12/12/2014 indicates that लिखी देवे notice in limitation matter to नेकी return to sender. Thereafter, the applications, the IAs for the plural, IAs number 453, 450, 449 of 2024 have been filed by the appellants. As well as IA number 454, IAs 454, 451 and 452 of 2024 for substitution and setting aside abatement against the respondents 1, 3 and 5. The notices which have been served on one Srimati Smita Rani, one MS Smita Rani Hutta, as indicated in the office note dated 12/12/2014, does not indicate how MS Hutta is related to the respondents 2 and 4. Today, when the matter is taken up, none appears for any of the respondents. Accordingly, notice be issued to the respondents as well as newly added substituted legal heirs by speed post with registration and proof of delivery, along with copy of this order, indicating that the matter shall be taken up for admission hearing. Requisites for issuance of notice. You have address or it will take a lot more time you require.
Lots of a fresh notice.
Yes.
Yes.
କେତେ ଦିନ ଲାଗିବ?
ସମସ୍ତଙ୍କୁ
7 days.
କଣ ଲେଖିବେ? Requisites for issuance of notice be filed after ascertaining the present correct address of all the respondents
ଟିକେ time
within 15 working days.
Yes.
The returnable date be fixed to 15 दिन ହେଇଗଲେ କେତେ ଆଜି ହେଉଛି 27 ମାର୍ଚ୍ଚ ଏପ୍ରିଲ କରିଦିଅନ୍ତୁ। Returnable date be fixed to ଏପ୍ରିଲ ହବ ଏପ୍ରିଲ 17 be fixed to 17 ଏପ୍ରିଲ 2026 list after SR liberty to mention. तो ज्यादा फ्लैग मार्क कर दीजिए इसमें लिखा हो ना। थैंक यू चलो ताजे रहो।
Yes, I'm just saying.
Yes, next please.
Item 16.
16, my lord, I have filed an intervention petition.
Intervention. Where is the petitioner, sir? Petitioner called Nandi?
On the last action, he was absent also, the petition.
J.M. Patnaik or Mr. Mohanty is appearing? Acha, they are for OP4. Apana intervener.
Yes, my lord.
Okay. Petitioner null. Mr. Who is appearing here in this? Mr. P.K. Sahoo, additional standing counsel for the OP number 1 and 2. Mr. S.S. Prasad for intervener.
Yes, my lord.
Intervener. None appears for the petitioner when the matter is called. No one is also present for the other opposite part. For the opposite parties 3 to 5. To grant further opportunity, list in the week commencing. Get Korantu.
Intervention petition डालो.
Intervention ताका absence से कोई लाभ भी कौन हो?
से आसु ना देगे.
कौन करा दियो? आपण जदि देखिबे आपण फेवर रे गला चुप देखंतु आपण तो
he is already serving.
13 माने 13 मसिया
unless you are affected, the lawyer should be happy. I can't tell about the intervener.
नहीं, I am appointed against the terminated vacancy. Due to pendants of this case, I am not getting my JA. That is my.
But the problem is that can you prevent him from arguing the matter? Let us suppose a record. Since the intervener is present and the petitioner is not absent, assuming theoretically, can I say that the matter is dismissed?
नहीं, वो dismiss वो intervention डालो ही.
देखो ना, चल जाए.
नहीं, वो intervention.
It's a very happy situation for the lawyer. Nothing is happening.
नहीं, वो intervention डालो ही जो है. वो intervention डालो ही तो तब decide नो, मुझे कौन कौन dismiss कर दो.
ताका absence है नो.
सीधे आसियो नहीं.
कहना अपन को effective prayer किस पे ही परिवानी.
Okay.
Either you go by the order of the court, it will favor you or it may go against you. I cannot say right now.
29/10 ଥିଲେ ସେ 29/10/25
तापरे वो नाहंते से के 15 दिन डेट रो नले
15 दिन कोन तो कोन तो
13 मसिया माटे मो दरवा मो ग्रांटी डेट को
लिस्ट में कमेंसिंग 16/3/2026
16/3
so we say week रे
16/3 रे मो भी रिटायर कर टाइम हे गेलानी मो दरवा पोने के
आपण को रिटायर कर आपण तो
तन वो क्लाइंट है
एग्जैक्टली
स्टे नहीं को तो स्टे
16/3
yes Mr. Venugopal has reached 90 I think still they are active so केमते भाबिले एबे केमते हो यू आर
30 वर्ष 25-30 वर्ष डायबिटीज हे गेला पर आउ
you have to manage it. It's a condition of life. Yes.
17.
None appears for the petitioner when the matter is called. To grant further opportunity, list for orders. So, what जोड़ा का जहाँ से तरह आसिबो अपन केबे 23 in the week commencing 23/3/2026. Yes, next.
18.
18 में memo is there. Mr. Arjuna Charan Behera for the petitioner. Opposite party blank. Correct. The matter being in the list was mentioned by the laureate counsel for the petitioner. At the beginning of the day's proceeding, he files stop query. He files memo of date, which states thus: to bracket SIC. But, the memo is taken on record. Scan copy be updated. The petitioner The petitioner husband in the marriage is before this court, challenging seeking a direction for passing the proceeding 162 of 2021, pending before the Learned Judge, Family Court, Hon'Ble. By order in the said proceeding, the salary of the petitioner was attached for realization of the rupees 7,000 per month to be paid to the decree holder, wife in the marriage, towards monthly maintenance. In view of the memo file, the petition stands disposed of. Maintenance granted under section 125 of the CRPC. Bracket elected stop. But in view of the memo file, the petition stands disposed of. Yes, next.
19.
Mr.
Your Lordship, the brief has been transferred to us. I'm filing the Wakalat Nama, Your Lordship.
Mr. Pratyush Naik.
Your Lordship, Pratik Naik.
Pratik. Mr.
Yes,
Pratik Naik for the chair, etc. Opposite petitioner, black opposite party. You are appearing, Mr.
I'm appearing on behalf of Mr. P. Misra for the opposite party.
Tushar Misra?
No, K. Misra. Ashok Mohanty.
Mr. Ashok Mohanty on behalf of K. Misra for the opposite party. You are Miss Chetna.
Chetna Prakash. Yes, Your Lordship.
Miss Chetna Prakash submits that Mr. Pratik Naik, Learned Counsel, Ms. Prakash, Ms. Chetna, as well as other Learned Counsel have instructions to appear on behalf of the petitioner as the petitioner has obtained change. Stop. The Learned Counsel who was appearing earlier has given consent for engagement of any other counsel. Name of Mr. Balram Naik, Learned Counsel, who was appearing earlier for the petitioner, shall be deleted from the cause list as well as the case brief. Name of Mr. Pratik Naik and Learned Counsel and associates shall be indicated in the cause list as well as the case brief appearing for the petitioner from the next listing onwards. 21. Any date?
Your Lordship, the interim order may continue, and date, if Your Lordship may be pleased to fix it to last week of March.
List in the as prayed for, list in the as prayed for, the matter shall be listed in the week commencing 30/10/2026. Interim order passed earlier 29/4/22.
Your Lordship, the order challenge was 26/3.
Oh, interim order dated?
Yes, Your Lordship.
Interim order dated 29/4/2022. So continue in the next date of hearing. Yes, please.
We are filing one IA that to vacate the stay interim order.
Have you served or you will serve copy?
No, I'll serve.
Okay. It is submitted by Mr. Mohanty, Learned Counsel for the opposite party, that IA copy of the IA number 387 of 2025 is served on the Learned Counsel for the petitioner. So, the Learned Counsel for the petitioner, Ms. Chetna, submits that he shall obtain instruction and file response to the IA if so advised by the next date.
Yes.
Yes. Next.
Item 20.
Pleased, Your Lordship.
Ms. Somi Das for Ms. Somi Das on behalf of Santosh Kumar Nanda for the petitioner. The matter the matter being in the list is mentioned by the learned counsel, Ms. Das, seeking adjournment. Accordingly, the date देते Set कर accordingly, the matter shall be listed in the week commencing 23-2026. Defects as pointed by the SR shall be removed within 7 working days. Yes, next.
31.
May I please, your lordship?
Yes.
My lord, kindly 3 working days may be allowed to remove the defects.
So what's your name, sir?
My lord, Bikram Narayan Das Chaudhary.
Bikram Narayan?
Sir, my name is Bikram Narayan Das Chaudhary, Advocate Bikram, but I'm appearing for the Susmita Prasad.
ଆପଣଙ୍କ ନାଁଟା କୁହନ୍ତୁ ବିକ୍ରମ ନାରାୟଣ ଦାସ ଚୌଧୁରୀ.
Yes, my lord.
Mr. Bikram Narayan Das Chaudhary on behalf of Alok Mahapatra, AK Mahapatra for the petitioner.
Yes, my lord.
The counsel for the petitioner seeks and has time to remove the defects as pointed by the SR. The defects shall be removed within 7 working days. List in the week commencing. 30-3-2026. Yes, next.
Oh, bless my lord.
22 on behalf of Mrs. Das.
Yes.
7 days time has been granted to remove the defects.
Ms. Sefali Das, I just forgot your name.
Sonali Panda.
So, yes, Ms. S. Panda on behalf of S. Das. For the petitioner, the defects as pointed by prayed for the defects shall be defects as pointed by the SR shall be removed within 7 working days. Yes, next please. Now respond on behalf of S. Jana.
A defect has already been removed today.
It is submitted by Ms. Panda, learned counsel for the petitioner, that the defects as pointed by the SR has already been removed. Registry to verify and proceed. Upon we dekhi diyantu. Why the noting is that not removed? Kindly check it. Acha. And it is submitted by the learned counsel for the petitioner. Likhte is Panda. It is item 23. The defects as pointed by the registry by the staff report has been removed today. Registry shall proceed in the matter for listing of the matter. Week commencing?
16.
16. The week commencing 16 बेसी हिला ना कौन? 16 दिन हैं? बेसी हिला. ताले 23 दिन कर दियो. 23-3-2026. Yes.
24.
24, my lord. And for the 2 RPF and my lord cases are there.
Yes.
In the first case, I am for the petitioner, and my lord, in the second case, I am for the opposite party. Here, my lord, we have filed 2 IAs for withdrawal of the
First, Mr. Barik is appearing in the first case also.
Yes, madam.
As for the respondent.
Yes.
In the first case, you have filed Wakalatnam.
Yes, madam.
Mr. A.K. Jena for the petitioner. Mr. Prakash Ranjan Barik for the opposite party. IA 96 of 26 along with RPFM 172 of 2024. The IA has been filed with the following prayer. IA टा कोड़े वाला नहीं आसिनी or 24 days, 1 second. Just 1 second. Maybe I had opened another brief. This paperless has this difficulty. Suddenly you can't realize what you have opened. The IA has been filed by the petitioner. The petitioner filed with the following prayer. फिर कोट कर देले accordingly copy of the IA has been served on Mr. Barik, learned counsel for the opposite party. Accordingly, the petition is disposed of. Copy of this order shall be forwarded to the learned judge, family court, to be kept in the records of CRP number 187 of 2019. Learned Judge Jajpur. Yes. Next. Same order, sir. Yes. Same order for Mr. Prakash Ranjan Barik for the petitioner, Mr. A.K. Jenda for the opposite party. Yes. IA our number is different. 87. IA 87 of 2026 along with RPFM 144 of
25. Yes, Mr. Dhir.
Yes, Your Lordship.
What done?
As Your Lordship will.
Okay. Mr. R.N. Prushti for the petitioner?
Yes, Your Lordship.
Oh, it is already for. Just 450.
Yes.
Mr. R.N. Prushti for the petitioner, Mr. Manish Dhir for the opposite party. None appears for the petitioner when the matter is called. List in the week commencing. 33-2026. Interim order is there.
Your Lordship, no interim order is there. Notice was issued on limitation only, Your Lordship.
Okay.
Your Lordship, may I pray a sooner date, Your Lordship, as because he's.
No, because what is okay?
As because he's not honoring the decree before the lower court, Your Lordship. NBW.
Actually, unless you are proactive, it has become really difficult.
Yes, Your Lordship.
They don't listen to any advice of the lawyer.
Yes, Your Lordship. Yes.
And they choose even in execution. Yes. They now they opt for going to civil imprisonment.
Yes, yes, Your Lordship. That is there.
26.
I'm much obliged.
Mr. Abhilas Mishra for the petitioner.
Here, my lord, the open judgment is.
Mr. H.D. Das, Himanshu Bhushan Das for the opposite party. Condonation of delay objection per
My lord, offer objection, my lord. But the petition is silent about the fact of the case, my lord. That is why I am asking my friend to serve me a copy of the brief, my lord. That is in RPFM. But it is not done why my friend was reluctant. However,
in Tarawan I have mentioned.
Convention.
What is
sir, ultimately to if I have to be confident
condon the delay, I have served the copy, my lord.
पारा 3
रिप्लाई का फाइल करंतु
हां
3-4 डेट आगे गलानी
कॉपीटा दे देले सेदिन तो कहलिन कॉपीटा दो गोटे कॉपीटा देले कर दियंता को ये कर दियंती एतर किछि लेखा
Mr. Das Learned Counsel for the opposite party submits that though the delay has not been condoned, he may be provided with a copy of the petition to help him to argue the matter. Learned counsel for the petitioner or the counsel for the petitioner shall serve a copy of the petition within 5 working days. Within 3 working days. Working days list in the week commencing
16th, that's next week.
16/3/2026. Yes, next week.
47.
Mr. Mahanti Basi Palele. So now, sir, it is time is 4:15 is the time, I think, official time. Total date kar diyo to fix kar diyo. Order should have on 3 ticket distribute kar diyo.
28.
Yes, Mr. Suman. Mr. Suman for the petitioner.
Your Lordship, I filed an IA for change of nomenclature, Your Lordship, from RPFM to CRLMP. During filing, I inadvertently filed.
Yes, Suman for the petitioner. IA 18 of 2026. The staff report dated 29/12/2025 indicates at paragraph 9 that at entry 9 that the petition is to be registered as CRLMP. The IA has been had direct counsel for the petitioner. She submits that the IA may be allowed and the nomenclature may be changed. The IA is favored and disposed of. The petitioner shall take steps for amendment of the petition for changing the nomenclature to CRLMP. How much time? Within 7 working days or 10?
Within 10 working days.
Within 10 working days. Yes. Liberty granted for listing of the matter. Yes. Mr. Jena has also left. এটা ଆପଣ ରଖି ଦିଅନ୍ତୁ ଖାତାରେ ରଖି ଡେଟ୍ କରିଦିଅନ୍ତୁ. Yes, next. Rest of the matters you can take ଯୋଉଟାକ mention ଗୁଡାକ କଲ୍ କରିଦିଅନ୍ତୁ. 32 ନା ଆଗ 32 ଆପଣ ପୋଷ୍ଟିଂ କରିଦେଇଛନ୍ତି?
Item 38
ସେଟା ଅର୍ଡର ପାସ୍ କରିବାକୁ ପଡିବ ନା ଆପଣ କରିଦେଇଛନ୍ତି? ପୋଷ୍ଟିଂ କରିଦେଇଛନ୍ତି? Phase 4 ରେ item 32, 34 କଣ କହୁଛନ୍ତି?
38.
30 ରୁ 34 କି Mr. Panigrahi, what do you want, Mr.?
Item 30 is there, Your Lordship, on the last
30.
30.
Yes.
On the last occasion, Your Lordship had directed that if there is any arrear, then I will pay 20,000, Your Lordship. Accordingly, I paid that 20,000 along with the other. And I'm for the IA objection was filed. IA has been filed for recall of the order of interim order, Your Lordship. To that, I am filing an objection, Your Lordship.
So since paucity of time has intervened,
Yes, yes, I will file it in the box.
Take a date. 30 টা date कर दियो.
4 weeks of date.
33. We commencing 33. Then next 31 to 34. Anyone mentioning?
I was 33. I am for the opposite party, man.
Yes, Mr. Mishra.
I am for the opposite party.
You want a date or
no,
any date?
Any date.
We commencing 33.
Lordship, 31.
Yes, 31.
Mr. S.S. Das is going to appear.
Yes.
Can I fix up any other date for arguments?
No, today for that. I mean,
Any other date?
paucity of time has intervened, so it will go to some other date. You want any specific date?
No, Chivita as per
So,
Lordship's convenience.
Your Lordship, I am appearing for Mr. Devas's conduct regarding item number 35.
Just 1 second. 31 टा गलत है. Next page. Item 35 ru 38. Yes.
Your Lordship, I am appearing for Mr. Devas.
35.
Yes, yes.
Mr. Panda is appearing for?
Pardon?
Panda I may appear with him.
For the opposite party, in favor Mr. Devas's conduct. For mention it to the top of the list, since it is cleared in the lower courts.
Yes, number. Top of the list करी होगनी. Computer doesn't permit that. सेटा how ही परनियो. जो आपनकर automatic listing mechanism जहाँ भी software अच्छी से तार serially करिवो. এটা আগুరు जो आपण हमें control करी पारथिलु when we used to practice there are some sort of control we tried we could control but सेटा होबनी. But the liberty, आपण the date नहीं होते the liberty to mention is always there. Hopefully
next working day.
केबे ही परिवो.
23.
We commencing 23 or you want early?
Early, yes.
Since then 16 होगा of course next.
Yes.
23 था ठीक अछि.
Okay.
Yes, because these are after notice matters. Yes.
Item 38 minute.
हम जाइनी से पड़ो. 36 टा आपनकर आपण कर दैछन. ठीक अछि. 37 अजन करछ ठीक अछि. 38 Mr. Raut.
I am the wife of opposite party. The wife is suffering and has coming to court this for his
was there. এটা কোন আপনার স্টে হে কি রয়েছে?
हां.
মানে মেইনটেনেন্স কিছু দউ নাহান্তি.
से 40,000 मेंटेनेंस ऑर्डर हेजी पिला भी उडे अछि. से पढ़ा पढ़ी पई से 15,000 देउजन जोटा आजुर उडे आरपीएम फाइल हेतला. ସେଇଟା ସେ ଚ୍ୟାଲେଞ୍ଜ କରିଥିଲେ ସେଇଟା ରିମାଣ୍ଡ ହେଇଯାଇଛି ପୁଣି ଆଉଥରେ ଆସିଲାଣି ସେଇ 15,000 ଗୁଡା ଇଣ୍ଟରିମ୍ କରିଦେଇଛନ୍ତି ଇଣ୍ଟରିମ୍ ଟା ବି ସେ ଦଉନଥିଲେ ଏଇ ଅପୋଜ କଲା ପରେ ଦଉଛନ୍ତି ତେଣୁ ସେ ଏରିଆର ପାଖାପାଖି ବହୁତ ହେଇଗଲାଣି ସେ ପିଲା ବି
ଆପଣଙ୍କର ମାନେ 15,000 ଟା ଡାଇରେକ୍ସନ ଥିଲା ନା ଡାଇରେକ୍ସନ ନାହିଁ ସିଏ ଦଉଛନ୍ତି ମୁଁ ବୁଝିପାରୁନି
ନା ଡାଇରେକ୍ଟ କୋର୍ଟ ଡାଇରେକ୍ସନ ଥିଲେ ଯୋଉ ଆଗରୁ
ତାହେଲେ ତ ଠିକ କରୁଛନ୍ତି ନା ଯଦି କୋର୍ଟ 15,000 କହିଛନ୍ତି ଦେବା ପାଇଁ ଏନାଉନ୍ସମେଣ୍ଟ ଫାଇଲ କରିଛନ୍ତି ନା କଣ
ଏନାଉନ୍ସମେଣ୍ଟ ଫାଇଲ କରିଛି
କୋର୍ଟରେ ଫାଇଲ କଲେ
ଆଉ ଦିସ୍
ଏଠି କେମିତି ଏନହାନ୍ସ ହବ 125 125 ର ଫାଇଲ ହବ ତାଙ୍କ ପାଖରେ ନା
ତଳ କୋର୍ଟ ଫାଇଲ
କରେକ୍ଟ ଆପଣ ଗୋଟେ ଜିନିଷ ଏଟାକୁ ଅର୍ଡର୍ସ କୁ ନେଇ ଆସନ୍ତୁ ଆପଣ ଆସିବା ଦରକାର ନାହିଁ ମ୍ୟାଡାମ ୟୋର କେସ୍ ୱିଲ୍ ବି ଟେକେନ୍
March, Your Lordship.
ଆପଣ କେମିତି ଚାହୁଁଛନ୍ତି
Your Lordship, a short date may be fixed.
ସର୍ଟ ହେଲେ ବି ଦେଖନ୍ତୁ ଦିସ୍ ଆର୍ ଆଫ୍ଟରନୁନ୍ ଡିସ୍ ମ୍ୟାଟର ଆମେ ଦେଇକି ସେଇଟାକୁ ସେ 16, 23, 30 ଭିତରେ ଆଡଜଷ୍ଟ କରୁଛୁ 16, 23, 30 16ରେ ବହୁତ ଗୁଡେ ମ୍ୟାଟର ଆଡଜଷ୍ଟ ହେଇଗଲାଣି ଆଇ ଥିଙ୍କ 16ରେ ଅଲରେଡି ହେଇଗଲାଣି
Your Lordship, amount of area amount of 19,600.
74 my list was already 74 it has to be distributed further 16 ରେ 64 ଟା already ଅଛି so there has to be some and there will be fresh matters also orders also so what we are trying to distribute it so 30 दिन is the upon jo question je it is a date very far off is not correct in many high courts you will find the sarkar the next date is at least 6 months in hearing matters the reason being you have to allow every case to be listed
Yes, Your Lordship.
because the pendency is so much if you give some date to when a particular case other matters are at least able to be listed so it is a common thing in many high courts that
I'm sorry, Your Lordship, but
no it's fine
the matter has listed after almost 7 years, Your Lordship. That
no
is the only
this
reason.
time at least be hopeful I am still hopeful that it will be listed in the week commencing 30th no difficulty yes
My appearance may be noted, Your
no ସେଥିରେ କାହାର appearance କିଛି ଲେଖା ନାହିଁ actually after 4:15 I cannot mark anyone absent or present no difficulty there since all of you are waiting so I am trying to look at the brief I mean list wherever the date can be possible I am just granting it.
Obliged, Your Lordship.
That 20,000 have you received?
Yes, Your Lordship.
So ensure that during pendency the person who is waiting for maintenance is getting it. That effort you have to make because when large number of cases are there so obviously the all matters cannot be taken up. Yes, next. Tapare 41 apni condition.
Item 39 kindly taken on next date.
39.
I am the petitioner man.
এটা কোন আপন জলদি চাହୁଛନ୍ତି କରିବା ପାଇଁ ନା କୋ
No, any date is
ସେ କରିଦେବେ no difficult anything specific to be told about any case then I was just କରଲା ତାହେଲେ 41 Mr. Abid Sahoo 41 Abid Sahoo for the petitioner Mr. Amit Prasad Bose for the opposite party. You take your seat, I have to dictate this order. Or you can, this is the last order, you can leave also, no difficulty. This is it's a matrimonial matter. The petitioner the petitioner is the husband in the marriage. Has approached this court under section 24 of the Civil Procedure Code seeking transfer of the civil proceeding MAT case number 31 of 2024 from the court of the Learned Senior Civil Judge Sundargarh to the court of the Learned Senior Civil Judge Senior Civil Judge Sundargarh likhile to the court of Learned Judge Family Court Sonpur Hello. Para. The matter being in the list is mentioned at the beginning of the day's proceeding before the court by the learned counsel for the petitioner as well as the counsel for the opposite party. Learned counsel Mr. Sahoo for the petitioner as well as Mr. Bose, learned counsel for the opposite party. Memo of date is filed having endorsement of both the learned counsel representing the petitioner as well as the opposite party. The memo states thus, the memo shall be taken on record, scanned copy be updated. Accordingly, it is directed the MAT case number 31 of 2024, pending before the learned Senior Civil Judge Sundargarh, shall be transferred to the learned Judge Family Court Hon'Ble, to the learned Judge Family Court Sonpur. Stop. It is further directed that the parties to the litigation shall make all efforts and shall cooperate for expeditious hearing and disposal of the matter. The learned Judge Family Court Sonpur shall also take up the matter as expeditiously as possible. As would be according to the number of cases pending before the said court. Copy of the application is favored and disposed of. Copy of the order shall be forwarded to the learned judge, learned Senior Civil Judge Sundargarh, as well as the learned Judge Family Court Sonpur, to be kept on record. Yes. You want to make a mention?
Item number 34.
34, yes. You want a date?
Time.
34 के बारे करीबे कौन? 23 वीक आसु 23 दिन में अपन 6 सेटरडे रखी सारे वीक में. Thank you.